But may I be permitted to mention one item for upgradation?
Upgradation, please wait.
Your Lordship, kindly bear me one.
Wait, dates have been fixed. I have taken some sleeps. Dates have been fixed. Please,
May I hand over my sleep, my lord?
please wait for a week. No use unnecessary because I
Yes, your Lordship.
upgradation, please wait
Wait,
for a week. Motions inclusion, please hand over the slip. Motions applications, extension, please hand over the slip. Extension, please indicate when it is expiring.
Your Lordship, I am seeking leave to file one matter pertaining to police inaction from the determination of Honorable Justice Subra Ghosh. Lordship, the urgency is the petitioner through their association.
File it will appear.
Your Lordship, kindly consider the urgency once the petitioners.
File it will appear. Mention the date in the presentation form. It will appear on that date.
Lordship, the thing is the petitioner wants to conduct a peaceful rally on 16th of February. There are only 2 working days in between. And the police are not granting me the permission in spite of my...
Indicate the date in the presentation form. It will appear on that date.
My lord, may I be permitted to mention a matter from the urgent list of Honorable Justice Subra Ghosh. This matter pertains to a bank fraud where the petitioner have bought a flat in 2012 by using a
Hand
loan.
over the slip mentioning the urgency. Yes.
May I have my lord's kindly to mention item number 965 of my lord Justice Ghosh's list.
Yes.
My lord, the matter can't wait even for a day.
Hand over the slip, sir, indicating the urgency.
The dying urgencies like this, my lord, I have Flipkart. My lord, I have a store. My lord, Instacart. My lord, for instantaneous delivery of my lord household goods, my lord, to the customers. Now, my lord, I have 300 employees in those 2 stores at Domdom. 5-6 employees, my lord, they are now preventing the other employees, my lord, from entering into the store and my lord, taking out goods for delivery. My lord, these
Please
2
hand over the slip mentioning the urgency.
was appearing, my lord, as item number 965.
Please mention the urgency
Great.
and indicate the item number and the date of the list.
I'll just check.
Kindly to mention, my lord, 2006 writ, my lord, affidavit in opposition not filed till date, my lord. There were 2 peremptory directions on the state, my lord. They have not filed any affidavit in opposition till date. I'm only praying, my lord, there are identical matters, 5 identical matters.
For hearing, it will be for hearing.
My lord, to be mentioned, my lord, because opposition, my lord, not filed.
At the time of hearing, it will be considered. Yes.
Mr. Basu is online.
Opposition, it will be without opposition.
Mr. Devajit Basu is online, my lord, mentioned on matter.
Yes. Yes, Mr. Basu.
Well, may I have my lord's kind leave to mention, my lord, a little bit embarrassing position, my lord. Tomorrow, my lord has kept, my lord, my matter fixed at 3:15. My lord, this unauthorized occupants. Now, my lord, Mr. Hassan would hand over you, my lord, a copy, my lord, with my lord's blessings, my lord, and I have been appearing in a matter before Supreme Court, my lord, where, my lord, the last Thursday the hearing was held. And my lord, their lordships has kept the matter as specially fixed tomorrow as top of the board. My lord, the orders also, my lord, Mr.
Basu, please mention when the matter is taken up. Ask your
my lord, I have given notice to my other side also. Only one day accommodation instead of Thursday may it be on Friday.
The other side is opposing.
Only one day, my lord. Tomorrow he is in.
Basu, your other side is opposing.
Lordship, may I be permitted to mention one matter from Honorable Justice Subra Ghosh's list, my lord? In this matter, my lord, I am a Bangladeshi.
Hand over the slip mentioning the urgency.
Tomorrow at the time of hearing, I shall mention, my lord. Tomorrow.
508 of lordship's list, there's an encroachment to a large water body.
You want upgradation? Please wait because there are many matters which have been data.
Well, tomorrow at the time of hearing, I mentioned this matter.
The one which I just mentioned, could it be, my lord? Could it appear as to be mentioned, my lord? Because this was your lordship's last order, my lord. It was
only I will consider at the time when hearing will be taken up. I will not allow them to file opposition.
In fixed March, my lord.
Item 45 of your lordship's list. Lord, item 45 of your lordship's list. On the last occasion, Mr. Basu only prayed for an adjournment and matter is now appearing as new motion 4.
Yes.
Lord, that matter where your lordship held prima facie that it is not maintainable. Thereafter, they are not coming.
Yes, they prayed for time. I have said tomorrow I will consider.
Yes, no, not this matter. Lord, in this matter also, Mr. Basu was there. He has prayed time on that day.
What
it is now not. I understand that Justice Ghosh's determination is also here.
You understand why are you mentioning?
But I am under extreme difficulty. If something could be done, Lord, your lordship has already heard us. Only on the maintainability, whether they will continue or they will withdraw the case and go to LRTT, that is the thing.
Issue. It's the most difficult issue to decide on the maintainability.
Your lordship's order is absolutely clear that it is not maintainable prima facie. Yes, prima facie. Now, Lord, if
Decision may change, Mr. Chakravarti.
Lord, yes, if not something, Lord,
My lord, I am
could be done,
intending
Lord.
to, because my lord, under compelling circumstances, my lord, will kindly grant me leave to file this application and allow it to be listed, my lord, whatever, wherever it is.
9.
My lord, yes, my lord.
Please indicate the date in the presentation form. It will appear on that date.
But my lord, some urgency was there because this is a case where a girl of 18 years have
When
been
do you want
assaulted.
it to be moved?
My lord, on Monday will be, because then
Please
some.
indicate the date.
My lord,
It will appear on that date itself.
my lord, I
Please hand over a slip.
slip টা করে দিয়ে দাও।
With a kind leave, well, this is in respect to urgent determination of Justice Ghosh, well, this is a bank fraud case, well, wherein, well, I have all,
Hand over the slip mentioning
well,
the
if some
urgency.
urgency, well, the,
Please indicate the urgency, Mr. Chattopadhyay. That is why I'm asking you to hand over the
My-
slip indicating. Hand over the slip.
I am for the petitioner, matter. I am praying for inclusion in the list.
Group 1.
Group 1 matter.
Motion or hearing?
Hearing matter. Motion, not motion matter.
Hearing?
Here.
No. Please don't hand over.
That review application belong last occasion, last Friday. the
Application.
Review application with my Lord Justice Supratim Bhattacharya. That review application while learning.
Date will be fixed. Please keep a watch on the list. Date will be fixed.
Your Lordship, Your
Yes.
Lordship, may I be permitted to mention a matter? Your Lordship has the determination of Justice Shubhra Ghosh, Your Lordship. Your Lordship, for non-prosecution, I'm mentioning before Your Lordship.
Please hand over the slip.
Lordship, deeply obliged.
Yes.
May I be permitted to mention one matter pertaining to the list of the Honorable Justice Ghosh. My lord, this matter was appearing. My lord, the last day, the matter was not taken up due to certain
Please take
problems.
your breath, Mr.
My lord,
Chattopadhyay.
contempt matters, my lord, would be taking up, my lord, has not mentioned, my lord,
When?
when, my lord,
Today there is some indication. Please go through the indication in the list. Yes.
My lord, I am the petitioner in person. On 9th, I prayed before Justice Subra Ghosh to grant leave so that my matter could be heard on urgent basis. The issue is that I am a MSME company owner.
Please hand over the slip indicating the urgency.
Hello.
Yes, Mr.
Her ladyship was pleased to direct the matter to appear today. But it is not appearing, but we know we had to mention this matter. Can it be taken up tomorrow?
Indicate the urgency, hand over the slip.
Your Honor, the petitioner is a senior citizen.
Yes.
The petitioner is a senior citizen. Actually, the writ petition is of 22, and there is no hearing at all.
Hearing, please. No here. It's at
No
the motion
hearing.
stage.
No hearing.
Which group?
Land matter, sir.
It was not moved.
Not-
It's at the motion stage.
Group 1.
Motion stage or
Yes,
hearing?
Hearing.
Hearing, not now. If it is motion, then okay. Please ascertain whether it's at the motion stage or at the hearing. Yes, call the list.
my lord, I'll be mentioning one hearing matter, my lord. Why
Hearing,
I'm
please.
saying, my lord, on 2 occasions, my lord, at the fag end of argument, my lord, the honorable judges got transferred. So, my lord, you, my lord, don't be
Take
taking.
that risk, Mr. Dho.
My lord, I am praying leave to mention one urgent
After I have
matter.
heard that, please don't mention.
My lord, I am praying leave to mention one urgent matter from the Honorable Justice Shubhra Ghosh, my lord.
Please hand over the slip indicating the urgency. Please don't mention that matter, Mr. Dho.
My lord,
Yes.
my lord, kindly, my lord, my urgency is, my lord, my property is, my lord, without acquisition, my lord, KMC is
First
utilizing.
submission which you have made.
That is damaging.
Yes.
Go.
Yes, call the list.
I am for the private respondents matter.
My Lord, I'm for the Union of India, my Lord.
Lordship, I am appearing for the union. I'm leading him.
Yes,
my
yes.
lord, this matter had appeared on Monday, and my lord had passed order recording submission of the private respondent that the subject matter of the sale deed on which the petitioner is relying upon, the petitioner is relying upon,
Yes.
the DAG number is 364, not 395. My lord, I have taken instruction from my client, and in my writ petition, I have made averment that the DAG number mentioned in deed is RS DAG number. LR DAG number is 395, my lord.
Where have you stated?
My lord, para 2, page 5.
Yes, Mr. Mukherjee, is it right? RS.
I have no instructions because
My lord, I have
that's the
downloaded.
positive statement.
that's his positive statement. But 1995 Lordship will kindly appreciate both LR and RS already had come, not
Lord,
that
I have-
subsequently.
But if the RS Dag number
And
has been mentioned,
even in that case, I am handing up Lordship certain documents. Lordship kindly says the
then I will hear both of you.
and secondly, there is a pending civil suit in which he prayed for ad interim order of injunction, which has been refused. And the learned trial court was of the opinion that he has not been able to made out even a prima facie case.
For ad interim injunction, my lord.
And Lordship kindly says the document which I handed up.
So because then I am keeping it, it was appearing under which heading? Today it's appearing under to be mentioned.
To
for
be
that,
mentioned,
but,
it is under motion. It was under motion.
let it appear, I will hear both of you then.
If Lordship allows me to file any affidavit, then if required.
Not
Up to-
necessary if it is, you have the documents, I think admitted documents, because what was in the suit, they cannot also dispute that.
My lord, I have downloaded a detail of the property from Banglar Bhumi. It also shows that the RS Dag number was 364 and LR Dag is 395.
Please give a copy to Mr. Mukherjee.
Okay.
The learned please supply the number of the extension of interim order
My lord.
application.
My lord, I for the petitioner.
Yes.
This is not complete, my lord. If my lord be kind enough to fix this matter any other day.
What is this matter?
My lord, the matter is regarding the Honorable Calcutta High Court passed an order directing the respondent authorities, land acquisition officer in Shuri, to consider the representation of the petitioner in respect to application for compensation in the property situated at Rampurhat. And in compliance with the order of the Honorable Calcutta High Court, the land acquisition officer issued a notice of hearing, my lord. We were present before the land acquisition officer, but the land acquisition officer did not record the name of the petitioner, but only recorded my name. And moreover, my lord passed an unreasoned order.
Which order you are challenging?
My
10th
lord,
of November 2025.
my lord, kindly come to page 38, my lord.
Yes.
Page 39. I apologize, my lord. Page 39. Annexure P6.
So you are asked to appear 10th of November. What order was passed on 10th of November?
They rejected my application, my lord, for compensation, stating that already the compensation was paid to the erstwhile owners, but they did not specifically mention the notification through which the erstwhile owners received the compensation, my lord. Because
for payment of compensation, no notification is issued. Show me the provision that notification is to be issued for that. Where is the provision for issuance of notification?
I am mistaken, my lord, but the problem is that they did not firstly, they did not record the name of the petitioner.
You are a purchaser.
Yes, my lord.
When did you purchase?
1984, my lord.
And when the property was acquired?
My lord, between this period, my lord, between 1984 to 2025, my lord. And they are stating that erstwhile owners, they have paid to the erstwhile owners compensation, which was before 1984.
Sir, award was declared, compensation paid in 56.
56, they are stating that, but my lord, if my lord grant me one opportunity, I will satisfy your lordship, my lord. My lord, if my lord grants me,
It's not necessary to serve even. Ashun, this, the petition.
Application under section 10 of West Bengal Highways Act 1964, which has not been considered yet, my lord. My lord, page number 15 is my representation.
Who is for the state?
My lord,
You are for the state.
I shall take instruction, my lord.
What instructions you will take?
Instruction না হলে তো পারা যায় না।
You are the owner of which plot?
Yes, my lord. Plot
Which
number
paragraph?
50, paragraph number 2.
The petitioner claims to be the recorded owner of
I am appearing on the petitioner.
Yes.
Private respondent till did not receive the copy of the petition.
Did not receive. It returned with the endorsement what?
No, this, it is kept in deposit. It is kept in deposit, but not
In deposit.
yet, Lordship. Kindly
What do you want?
mutation of the property, Lordship.
Mutation of the property before
BLO. Yes, Lordship.
Already district land.
tribunal. Asun.
I appear for the state respondent. In this matter,
I appear for
petitioner
the,
lordship.
in item number 5 and 6 in both these matters, my lord, I am appearing for the private respondents. Some of the private respondents, my lord, I got the brief only
This is
a
for
few minutes back, my lord, I got the brief, my lord, I could not get into the matter.
Served on lordship 10th.
Lordship kindly takes up the matter on Monday.
This is for removal of encroachment lordship over the.
I
PWD
understand
road.
that.
My representation lordship is at page.
I'm directing them to consider.
My lord, even then, my lord, I beg for some time, my lord. Let it be taken up on
All right,
Monday.
On the pair of the learned advocate for the
Monday. My lord, I have
the authorities to consider. You can place all documents.
my lord,
before
what
the
happened, my lord, the brief I have received is incomplete as yet. Lordship kindly takes it up on Monday.
Monday.
Same position. Lordship.
Yes.
5 and 6 lordship same matter.
Same position that I cannot assure. Yes, next. 6 also you are appearing for the private.
My lord, my lord. I for the state.
Yes, please give your appearance.
By the private respondent, but my affidavit of service has not been completed yet. But I sent, but the track report I have not been.
The learned advocate appearing for the petitioner submits that the service upon the
May pleasure, Lordship. My lord, acquisition of 2003, award of 2006, possession handed over 2003, award declared. But notices which were served by the state was upon a dead man, the then owner, my
Section
father.
18.
Yes, my lord, award is declared, but I have come, I have made a representation to the collector, asking him to decide the issue, including payment of interest and damages, because 66 decimals of land has been acquired out of 65 in a haphazard manner, and leaving apart, my lord, 2 decimals of land. Now I approach this court when a probate application was pending. My father has given a will, executed a will in my favor, and the will has been probated. Now I have come by virtue of a liberty.
Yes.
Now, my lord, I have made an elaborate representation to the collector, my lord. That is at page 50.
For higher compensation and demarcation of unacquired land.
But higher compensation pass is left apart. But I am not pressing for that because I am
not demarcation.
My lord, he filed an application as our declared payment is not disbursed.
So you have not received
No, because it was
notice.
noticed.
Mr. Dev, what is your instruction?
My lord, instruction, I may not want to take instruction, my lord. If your lordship will come, page 42.
Page 40?
40, 41 and 42.
Yes.
He is not taking the award money. 42 is
Not
the award.
taking village, but my date of knowledge is through a.
अरे बाबा
Yeah.
तुम्हार फेवरही बोलबो तुम्हार फेवरही बोल वही क्या
For your other side, but he is supporting you. This here is submission. Yes.
My lord, so my lord, he filed an application, my lord, I must pay the amount. That is the amount is there, my lord.
Yes.
Award, there are so many awardee, my lord, but he is not taking the award money.
He is for whom?
That is Sotto
Prasanna Khan.
Prasanna Khan, my lord.
Prasanna
Khan.
That is 42, my lord, 2 lakhs, 9,064.
Prasanna Khan, that is award
Serial number
serial number
34.
34.
Yes, my lord.
And only one.
Only one.
Only one, my lord. Other my lord take the money, that he is not the.
Now
So,
what do
my lord, so he filed an application, that application will be considered and pays the money within certain time.
My lord, all points may be kept open.
Yes, boy, তাতে আমাদের কিছু যায় আসে না। তুমি
you are not paying for higher compensation? You want
interest under section 34 of the act.
My lord, he
want that.
My lord, if your lordship will see.
And my lord, my lord,
paragraph
2 decimals of land is still remaining, which they have not acquired. Out of 68, 66 is not acquired.
That is, my lord, he
And
filed
2
one
decimals,
application. We must consider that, my lord.
There is no trace of
Then I
that.
am directing them to consider this representation.
Yes, my lord. Yes, my lord.
My lord, affidavit of service is there. My lord.
দাদা দুটোই দিয়ে দেন পরেরটা ও আছে পরেরটা
So what are the reliefs you have to fix a quantum of compensation according to the present market price?
How he get the that, my lord? That can't
demarcate the vacant land.
No, my prayer is
not in the representation your prayer. They will consider the representation. They cannot consider your writ petition.
My lord, when that representation was given address to the authority, well, at that time they were of the opinion that they are going to get higher compensation.
So you want to file a fresh representation?
Yes, my lord.
I give you that liberty. That will
Lordship,
be considered.
Yes, my lord.
Lordship.
Well, same order.
Similar,
Similar.
similar application.
Representation date is also same.
Representation date একটু রেখে নাও।
So they are also mirrored that higher compensation.
So same order.
Same
The
date.
payment notice was served.
Yes, yes.
That was also upon
Yes.
the dead person.
Yes, my lord.
Same order. Next. Yes. Yes, Mr. Ghosh.
Well, before my learned opinion can start, well, I have a point of maintainability of this petition.
Maintainability.
My lord.
Raise the point of maintainability first.
My lord. My lord, kindly takes up the order impugned which is under challenge before your
Order
lordship.
impugned, which is under challenge. What is the order?
154. Page 154 it starts.
154.
54. Page number 154, my lord. Well, it has been passed by the district magistrate in the capacity of a collector. Lord, as per the section 54, Lord, the appeal will be before the divisional commission. Lord, I am led by Mr.
Huge fact. This is a proceeding under what act?
Lord, it is not a proceeding under but the administrative order of the district magistrate was challenged before this honorable court by the first writ petition. Lord, that order was thereafter, Lord, second writ petition was filed. The second writ petition, Lord, your lordship.
This order is passed in what proceeding?
Writ proceeding, Lord, this
this order dated 31st of or 25th of August 2025.
Yes.
Was passed in what proceeding?
Page 143, Malkanshi.
143. No, this may be pursuant to a direction. Mr. Ghosh, I am asking you in what proceeding?
Lord, an administrative order by which my land without notice was handed over by one department to a PHE department for construction. Though I am in possession, and Lord, the record of right was directed to be corrected on the basis of the civil court's judgment and degree, which was in my favor up to this was affirmed up to this honorable court in second appeal. Thereafter, Lord, I applied before the BLLRO for correction of the record of right. That was not done.
It was done. Correction was made in terms of the civil court.
No, it was not done. The application was there. Thereafter, a direction from the LRTT that it should be done by the BLRO. He rejected it. Thereafter, appeal was prepared. In the meantime, what happened during pendency of this?
What was the subject matter of the suit? Challenging the vesting order?
Not vesting order, Lord. What happened? Yes. Initially, in 1348 BS, on the basis of an Amolnama, the original owner, he handed over possession of the property, followed by the rent receipts. But thereafter, after coming into operation of 1953 Act, Lord, my name was recorded as Rayat in respect of the said land. Subsequently, that is
agricultural land or non-agricultural land?
Agricultural land.
Agricultural land.
Yes. But thereafter, what happened, Lord, in 1966, my name was recorded and finally published. I had been paying revenue. Thereafter, in 1972, a suo motu proceeding under 44(2)A was initiated against the erstwhile owner, that he is a big rat and said that he is vested. Lord, challenging that order, I filed a suit before the honorable court.
Mr.
Before
Ghosh, that issue is pending before the larger bench.
Lord,
whether the civil court has jurisdiction to decide that issue. That's pending before the larger.
Lord, before the just yesterday, the division bench of Justice Sabharsaji Bhattacharya has let it be there. He has passed an order that civil court's degree cannot be passed. Cannot be, Lord.
That issue is pending.
But Lord, here kindly see.
Larger bench issue is pending. There's a Supreme Court decision directly on that point.
But Lord, just yesterday, I produced before your lordship. His lordship held that once the judgment degree is passed, it is binding upon the parties. Therefore, it cannot be avoided. Lord,
what happened after that?
Lord, what happened after that? Lord, thereafter, BLRO rejected my application on the ground 57B. Appeal was prepared. In the meantime, but it not proceeding was not concluded. In the meantime, Lord, the government has handed over the possession to PHE department, Public Health Engineering Department. Lord, they put some signboards that it is our land. Lord, then Lord, we approached the DM, District Magistrate. Lord, that 121, page 121. Lord, he rejected our application. Challenging that, we approached this honorable court. This honorable court directed that this should be done and quashed that order. Subsequently, again, the district magistrate rejected our application. We approached this honorable court. by the order.
What was the prayer before the district magistrate? What was the prayer?
Prayer that it is my land, it is yet to be recorded in my name on the basis of the civil court's degree. You cannot take possession of my land. That was the by administrative order. That was my challenge.
Please show me the challenge which was thrown before the district magistrate. Please show me that.
Page 121. Can come to page 121.
Well, everything recorded in the order impugned. If your lordship kindly, well, all the
Come to
facts
that,
are made.
please let me see the scope of this, because your learned junior has taken the point of maintainability. So I must see what's the foundation of this proceeding. So this representation was ultimately disposed of by the DM.
Yes, it was rejected.
Yes, Mr. Sen. Is it right that page 121 was ultimately disposed of by the DM?
Yes, by the 121 ultimately disposed of. I just received the brief yesterday night, my lord. Huge, my lord, facts at page 162.
No, this 121 was disposed of.
Yes.
How an appeal is maintainable against this type of order? Under what provision of the statute?
Yeah, no, you understand. We are order. No, no, reject. That order was not quashed by this honorable court in the second writ petition.
Which order?
The order passed, earlier order passed by the.
No, this application has ultimately been disposed of by this order.
Yes.
However,
But these
how
are,
did the appeal, how did the order is an appellable order?
these application, what it appears from the, my lord, the statements or averments made therein, page 121 to, my lord, the end of the representation at page 127.
Yes.
That the aim of the administrative authority was requested to look into the matter. And stating certain facts.
Yes.
And my lord yielded everything to him that I am surrendering this. Whatever you do it. This type of representation.
No, maybe, but
I am telling.
How can you say this is an appellable order? Under what provision of the statute?
No, my lord, that may not be. I am not on that. That may not.
Then I will hear him on.
Yes, yes. That
There is the point of maintainability. That is
maintainability still is there, but on other way. I'm coming.
That I will hear.
On other way, yes.
Not that it's an appellable.
This is what, Malad, just now I go
then
through
let
it.
me hear Mr. Ghosh.
Yes, but only thing is this, Malad, just a minute. That eventually, my lord, at the end of the day, I think, my lord, whatever very, my lord, rapidly I have gone through, and eventually at the end of the day, I think that matter disputes, my lord, relating to that what fell from your lordship, that the right accrued by the civil court order, and that has not been, my lord, acted upon by way of correction of record of right by the BL and LRO. That grievances remained according to them. Because originally...
But recording cannot extinguish the title. Title has been declared by the civil court. Maybe the records has not been corrected. Title you cannot dispute. So if he is the owner, can you forcibly take away his property? That's the small issue which you have to answer. I accept that it has not been recorded in the record of rights. But till now, the decree has not been declared to be nullity.
No, that is true.
So he is the owner.
I have gone through first appeal, second appeal. I have gone through. Now, my lord, Well, this question, my lord, I have to consider. Lord, see, my lord, certain, my lord, I need some time.
And the question is whether you can take that point of nullity now.
Yes.
After Supreme Court, that's also is an issue here.
No, I think, my lord, that the
In the suit,
yes,
if it was a contested, the first paragraph of your written statement would be the suit is barred. So when you have lost, so that objection of yours have been overruled. If it was a contested at one point of time,
but
if not in the suit, in the appeal, you are the appellant.
whether
your
barred
first
or
point
not,
will
Lord,
be-
see, my lord, so far, my lord, Section 3 of the Limitation Act, my lord, itself says that whether I have taken that plea or not, court can always take that plea,
it's an
that
issue
barred or
decided.
not.
Yes. It's an issue decided. If it is an issue decided, because even if you have not taken, if it was an ex party, you have preferred an appeal. In the appeal, that would be your first ground. So first appellate court has decided that issue because he won in the suit.
He won in the suit and subsequently
even
all
if it was an ex
subsequent
party, so it was your appeal. So that would be your ground. So issue was decided binding between the parties. Now, can you again reopen that issue of bar of 57B?
Initially, it was, my lord, that yes, initially record of right that was corrected under Section 57, and then they filed suit, everything.
In the suit, there was no direction for correction of record of rights. Then Mr. Ghosh would not have approached.
No.
Because that's not maintainable.
No. Yes.
Only a declaration of his title and maybe declaration that the recording in the record of
I
rights
think suit was
erroneous.
Suit was for declaration and injunction.
Injunction,
possibly.
maybe to the extent of declaration that the recording is erroneous in the record of rights.
Yes.
To that extent, but not with regard to the direction for correction.
No, there was no such.
So if that declaration is there and title is declared, even assuming that it has not been recorded, not executed, but title, he is the owner.
No,
because
Madam,
mere wrong recording or non-recording in the revenue records neither can create title nor can extinguish the title, which has been declared by the civil court.
just like mutation of the property.
Everything. It's a mutation. It's only for the purpose of collection of taxes.
True.
Nothing more than that. And it has one presumptive value of the issue of possession. Now, when he has won in the suit, declaration, injunction, so that presumptive value of that record of rights also.
Another thing is, Lordship, that so far the other proceeding, so far the other proceeding that initiated by the my lord at his instance. Now another proceeding started at his instance. He made representation for correction of record of right. That was rejected. Then my lord, he took step for my lord the challenging the same. Then my lord filed writ petition. No, prepared an appeal before the appellate authority. Then appellate authority rejected. Then
it is pending till now.
It is pending. Then let it go there.
Accepting your submission.
Then let that be, my lord, disposed
Accepting
of.
your submission to the highest level.
Let that be
prayer
disposed
for recording or mutation has been rejected, but that cannot extinguish his title. He will not be liable to pay any revenue taxes. Title has been declared in his name.
No, but the question
You
is
will
that
take that advantage. You will say, I will not pay any tax.
question is that another proceeding,
For the purpose of collection of taxes and other things.
another proceeding
is for your benefit that you have to mutate. Because title now you cannot say that issue has already attained finality. It's res judicata, Mr. Sain.
my lord, then the question remains that whether that is binding upon the state authority with regard to that.
Must be you are a party. If the vesting order is challenged, state must be a party.
Yes.
Where is the vesting order? Where is the order decree passed?
But I don't think one of the plaint is not here.
West Bengal is the
That
appellate.
the
Page
vesting,
34.
vesting order or my lord, the
Mr.
correction of
State,
record
State
of right.
West Bengal is the appellate.
Yes, yes, yes.
Page 34.
Yes.
You are a party.
It was decreed against them on contest and against others.
On contest. So
Yes.
it's a better footing now.
And Lord, Amolnama was challenged by them. It has been on evidence found that Amolnama is genuine. And there are rent receipts followed by rent receipts. Specific finding on evidence. They failed to produce any document to show that this is.
No, I am
fake.
just, my lord, I just want to, my lord, check it, that whether the order of vesting was challenged or not. If that is not, then my lord, there may be that the my lord, avenue is still open for
Lord,
the state.
Lord, second 44-2A proceeding was quashed.
Yes. Now, Lordship, kindly come to my lord, because I just received yesterday night. My
53.
lord, Lordship, kindly come to page 37. Page
37,
page
yes.
37. My lord, this is the, I think, my lord, the
37 is the body of the writ petition.
no, no, page, এটা কত পেজ, ও সরি, এটা অনেকগুলো ইয়ে আছে, পেজ 57, page 57.
Yes.
That is the order.
Page
Judgment.
57 is a judgment.
Yes.
Now, Lordship, kindly come to the middle portion.
Yes.
This is a suit for declaration and injunction.
Yes.
What was the prayer in the suit that is, my lord, enumerated here?
Please
The-
kindly come to page 58, third issue. Is the suit barred under the West Bengal Estate Acquisition Act?
Yes. This has been decided.
No.
That was the specific issue raised.
I'm coming
Decided.
to, I'm coming to one after another. My lord is very fast, I may not.
No, no, no.
Lordship,
I'm not that fast
kindly,
like you.
kindly,
But
kindly,
just
my lord, kindly,
I
my lord.
turned over a page and issue.
Yes, Lordship, kindly come to my lord.
Correct me.
That, my lord, the first page of the judgment. The case of the plaintiff, in short, is that co-schedule, it should be land, which comprises the co-schedule lands belong to defendant number 4, who settled the same in favor of the plaintiff.
Mr.
In Rayati interest.
Trouble yourself, please kindly come to 63, operative part of the judgment. 63.
First, Lordship, the issue.
44-2A was.
That is, yes. See.
Please see the judgment.
Page 63.
63, operative part.
Operative portion. Order portion.
Yes.
The suit B and the same is decreed on contest against defendant number 1 and ex parte against the rest. I make no order as to cause plaintiff's title in co-scheduled land is hereby declared. The proceedings under 44-2A of the Estate Acquisition Act is without jurisdiction. 42A is that my lord,
thereafter
that recording
is restrained from disturbing his peaceful possession. This decree is binding against you.
defendant are restrained permanently from disturbing plaintiff's possession, not ownership. I'm coming to one after another.
Title is declared, Mr. What are you saying? Title is declared. You have been injunction restraining from possession.
In co-scheduled property.
Yes. So only co-schedule.
Only.
So we have to see what is the co-schedule.
In co-scheduled land
will be
is
the
hereby
decree.
declared.
So Mr. Ghosh cannot claim anything more than co-schedule.
And the proceedings under section 44-2A of the estate, that is regarding the
What schedule is that page 66?
Exactly the same land.
Page 66 is the co-schedule. You cannot travel beyond co-schedule. And you are restrained from co-schedule.
Yes.
Yes.
So you cannot dispossess him or to disturb his possession in respect of this plot. This decree is binding against you.
My lord, I need some time, Lord, so you kindly give me, my lord, today.
Mr. Ghosh, what any interim protection you want?
All through interim protection was there. Your
What
lordship,
interim protection you want?
Lord, not to do anything in the land, not make any construction.
Yes. Mr. Shane, you cannot make any construction on that.
Who is constructing?
PhD department, Public Health Engineering Department.
It's a wing of the state of West Bengal.
Yes.
And state of West Bengal is
Party
being
commission.
restrained. Huh?
পার্টি করেছেন? Should kindly, my lord, let there be an interim protection, but what can be done? Because if the balance of convenience in tilt in his favor, I cannot stand in the way. But Lordship, kindly give me, take it on another day, a limited time
What
interim
is the
protection.
relief which you want, Mr. Ghosh? The main ultimate relief, what is? What you want?
No, kindly see the list.
Cancel and withdraw the impugned order
Yes.
dated 25th of August 2025.
In fact, this order passed by the district magistrate, I do not think that under the provision of any law, but at the aim of the administration, he made a request.
That is why it cannot be an appellable order. That's the objection of Mr.
No,
Ghosh.
no, no.
So that's the
Not
objection
under
of-
the provision of this
Yes.
statute. No.
Because he has not decided any issue under
No,
the
no, no.
either
Just
the
a
Estate Acquisition
representation
Act or
was
the
made.
Land Reforms
Just
Act.
a representation was made that these are the facts.
Yes, yes. That's
And-
why I asked.
And he was
First I asked Mr. Ghosh, what's the basis of this?
he was asked to look into the facts. Yes.
Deprive, Mr. Ghosh, where have you stated this? Mr. Sen, this matter can be disposed of, otherwise unnecessarily keeping this pending. Because the prayer, if you have seen, if you want time, I can give you time. But no use keeping this matter pending. Because please see page 126. Last paragraph 126. Have you got page 126?
Yes.
So please see last paragraph of that. He says, cannot deprive my land and take illegal possession without permission, without acquiring. Because you can acquire that property.
Yes.
Nobody can stop you from acquiring.
No, my lord, may I tell, my lord? That means, my lord, the disposal of everything, including, my lord, finality to all the issues, whatever raised before your lordship, rightly or wrongly. My lord, the lordship, kindly give me some time.
Yes,
I think, my lord, if that is no, lordship, kindly give me.
No, I'm not disposing it of today.
My lord.
Telling you this
Yes,
is the
yes, what
scope of
fell
his
from
representation.
Yes.
So instead of keeping it on another day, if you can come on any day in the next week, I think it can be disposed of at the motion stage itself. Because all these facts, Mr. Sen, the decree has already attained finality. Title of Mr. Ghosh's client has been declared and you have been restrained from taking possession. Unnecessarily keeping this writ petition pending with that interim order, because you cannot say that because they are entitled to.
No.
Civil court's decree restraining possession is that.
Lordship, kindly consider one thing.
So only whether this order, whether the basis of this order
But-
is correct or not, you have to submit only with regard to those admitted factual position.
What are the prayers here?
Yes.
It's not same thing.
Prayers, Lordship, kindly
Yes,
have a look.
prayers in the writ petition.
Page 40.
Cancel, withdraw the impugned order dated 25th
Yes,
of
that's the
August
order which is
2025.
challenging.
Yes. Then
And then commending the concerned respondent
Construction work
to stop illegal and unauthorized construction work on the
state
petition of coastal
restraint.
line.
What can be? This is in aid of the injunction order, decree for permanent injunction, which is in their favor. That is why I'm telling you, because
stop illegal and
taking the prayer, everything is in aid of the decree of permanent injunction and the declaration of title.
Co-schedule.
Work on the petition.
Yes, co-schedule. Mr. Ghosh cannot get anything beyond co-schedule.
In violation of the civil court's order,
we
without
have to
acquiring the same in
we
accordance
have
with
to
law.
compare the co-schedule in the plaint with this prayer arrest plot number. এগুলো
Yes, yes.
দেখতে হবে।
That
Compare.
Mr. Sen,
এগুলো দেখতে হবে।
that I'm telling
degree.
you, Mr. Ghosh cannot claim anything beyond co.
Lord, degree at page 66.
Beyond co.
Yes,
That-
Lord, that is so.
That Mr.
Lord, I have described here.
Yes.
Page
Lord,
66. That is the degree.
Because this is the scope of this.
No, I think,
petition
my
is
lord,
very
for the time being, my lord, if he's, my lord, whatever is right flows from the, my lord, the degree or culminated to the, my lord, whatever. Now, my lord, if it is protected for the time being, and if some time is given to me either to file affidavit or a report, lordship kindly.
Affidavit, because it's
Everything is there.
the order which is under challenge. Can you expand the scope of the order by way of an affidavit, Mr. Sen?
My lord,
You are telling that the scope cannot be enlarged by filing affidavit because he is challenging only the rescind order.
Yes.
And these are the admitted documents which are there, decree and other things. You cannot improve upon that, expand the scope of the order under challenge by way of filing of an affidavit.
No.
That will unnecessarily go to the hearing stage. This matter will be kept because
But
the
that
issue is very small.
issue is small, but facts are huge. Facts are huge. Issue is small.
That is
So
why you
let us go through the
take
facts.
instructions.
And my lord, may I have instruction and may I come back? My lord can give him, my lord, a temporary protection. I am not on that. If it appears that prima facie his right title and interest that is there, let me, my lord, come back with the instruction from the, because after all, state is my client. Lordship kindly consider.
Mr. Sen, I'm not
Now, my
saying that
lord, I at the same time when he is, my lord, protecting his client's interest, I have to, lordship kindly consider. There may not be that at the end of the day that it will appear that there is nothing on behalf of the dependent or the respondent. But lordship kindly give me.
When do you want it to be taken up?
Lordship, 2
Next
weeks এর
week,
মধ্যে
any
পারবে
day?
না? 2 weeks time be given. In the meantime, if my lord so wishes, we can file our affidavit also.
Affidavit not necessary. Affidavit not necessary. Please come. If there is a factual dispute, I will consider that. Affidavit, if your junior wants that for any other purpose, then
No. On behalf of state, affidavit.
I'm not telling you if your junior wants for any other
ফাইল করতে
purpose.
চাইছো এটা করে দাও না
ঠিক আছে আপনি বলেন
আরে তোমার তো 2 weeks টাইম পাচ্ছ কি আছে
ঠিক আছে
Why only junior?
Deny dispute
Senior
and
will settle it.
The Thank you, Mr. Singh. Yes, call the next matter.
My lord. I am for the petitioner led by Mr. Shoptangshu Basu. Mr. Basu is appearing virtual.
I have been requisitioned by the.
So Basu has now started appearing virtually. He is not.
What can be done? Your Lordship Chief Justice has requisitioned me in a matter. You have to come to first sitting of my circuit bench.
Yes.
My Lord, this is an application. I have filed. An allotment was given to me in the year 1975. Upon payment of the upon payment of the initial money, the balance money we have to deposit within a specific time. I could not deposit due to my various problems. But the state authority taking a policy decision, the persons who was unable to pay the balance money will be time will be extended. That extension was by time to time for 25 years. It was extended. My case is that in 1996.
Mr. Basu, you want to be extended further by 25 years?
No. I am within that period. What I am saying, in 1996, my application was with the authority. If the 25 years is the total date from the date of allotment, then I am coming within the purview of that period. Justice Pattanaik, just a minute, my lord. Justice Pattanaik, in his judgment, my lord, categorically hold that my application was pending when this extension was granted. After holding that, his lordship was pleased to direct the authority to consider my case. But what they have done.
Show me that observation.
My lord.
Show me the.
Kindly come to page
71. 71.
That's true. Is 71 it starts? Kindly come to a 78.
Yes.
My lord will find that the Justice Pattanaik hold that my application was pending on that date.
So which portion? Mr. Banerjee, which portion says that?
Lordship will kindly come at the bottom, last line. In reply to the letter, 78 bottom.
Inform that validation of cannot be made since the same has already been cancelled
due to non-payment of balance salary. Then it is relevant to note.
Yes.
That within the year 2000, which was extended period for the petitioners, the representations of the petitioner dated 24th June 19
was pending.
Which
were not dealt with and considered.
Therefore,
then what was the direction passed? This 26th of October, 2nd of November was set aside, directed to consider the representation in terms of the notification for extension. Then what? Where is the decision thereafter? What is the impugned order, Mr. Basu?
93. Page 90.
But it was directed to consideration.
Yes.
They say that now they considered it now. So now I have.
Now, Mr. Banerjee has now started appearing for the authorities also.
If it is considered today, I am out of time. Yes. Now, what they are doing, now they are considering my application today.
Point out to him. They will start shouting.
Mr. Banerjee has now started to appear before the authorities.
Yes. Since long back. Since long he is appearing.
Yes. Show me the reasoning part. Show me the reasoning part.
But can I come to the last page?
Yes.
Mr. Banerjee, can you
page 5 of this. Internal page 5 of the order.
Yes, page 5. Paragraph 15.
Paragraph 15. Or before that, my lord.
Yes.
It appears that other provisions of memo dated 8/7/1988 shall remain unchanged. So, the memorandum subsists on genuine details. The family dispute as raised by the petitioner in the representation cannot be termed as unforeseen compelling circumstance as per object of the memorandum. It came to notice that when the petitioners made the representation on 24/6/96, the memorandum dated 31/12/2001 was not there. Even on that date of notification, that is 31/12/2001, it came to notice that 26 years have lapsed from the date of allotment. This is the ground taken.
Permits cases only 25 years from the date of allotment.
And the representation was within that time, 1996. But the notification came subsequently, so it has to be applied not for the cases where the applications were already there.
Please show me this notification once.
2001 is not at page 50.
So this is the only reason.
This is the reason. I am not know. The next page, they also say that this is not a hardship under the notification.
First comes to the finding that it is not applicable. It was not there in 2000.
Then on merits.
Then on merits says that it is.
Show me the notification.
Page 50.
Page
50.
50.
50. Typed copy. Before that, Lordship will see the first notification because it was extended. The reasons your Lordship will find. No, this also contains. Page 50 also contains.
Page 50.
50.
Yes. So this is the notification which was considered.
Last notification.
And where is your representation which was pending at that point of time?
1996. It was in 1996 which was pending.
Show me that
44.
representation page.
44 to 48. Not
44 to
48. All the representations.
So this was kept pending when the notification came into force.
Yes, to altogether, Ballot, kindly consider altogether 25 years extended. So I am coming within the purview of that period.
Yes. Now let me see the notification. What is the relevant portion, Mr. Banerjee?
The first paragraph will give the reasons. But what are the circumstances which is not inclusive? Inclusive definition.
So you paid the initial payment of the salami in full.
Yes.
No, 50%. 50%.
Initial payment of salami in full.
Initial in what was demanded? 50% was demanded.
Yes. So initial in full.
Paid.
And where does it say that it has been extended for a period of 25 years?
Paragraph
altogether. 3 notifications are there. In cumulative effect, it's 25 years.
Page 50, last 3 lines.
Actual measurement in cases where the full payment of salami in terms of was made in time may be extended in appropriate cases. What is your ground for not paying this within or for not?
We had a family dispute. Family dispute was there.
Page 40.
That is not included in the notification.
Family dispute was, where is that?
Page 44. Oh, in notification.
No. Your ground for the delay.
Ground page 44 onwards. 44 to 48.
Show me that you are coming within those. What was the reason?
Kindly come to second paragraph, Miller. First paragraph I say that I have deposited in full. Then unfortunately at this juncture, between us, as a result of which we failed to deposit the required amount towards the cost of the above plot. Although extension of time was granted to us, but we failed to resolve our differences. In consequence, the stalemate remained. However, by grace of God, some good sense has prevailed upon us, and we have already resolved our differences and agreed jointly to deposit the balance money towards the cost of the above plot to be found due and payable. Under the circumstances, payable. So this is the first representation.
So it's a family dispute.
Family dispute leading to because of the dispute, the money we could not gather.
Yes. Yes. What do you say?
My first submission is this, my lord. The direction passed by this Honorable Court in earlier round of litigation was to consider the representation in the light of the 3 notifications. This one 88, 91, and 2001. Now, when they have filed this representation, that is on 1996. At that point of time, 2002, one notification was not there. That is why we have not considered initially, my lord. And second,
that is why you have not.
But we have not considered 2001 notification. We have considered their representation in terms of notification 88 and 91. And as per these 2 notifications, 10 years and 13 years were extended. And when they have submitted the representation, that period has already elapsed. That is why we have not considered as per those 2 notifications.
What is the law? If this application was pending, in the meantime, a notification comes. Whether they are entitled to benefit of the notification which came into force during this subsidy, because you have not rejected earlier. That application
it is automatic rejection. It is automatic rejection because they have failed to deposit the balance amount.
Rejected, no automatic rejection, but that's not the ground. You have not said that it was all automatically rejected.
Yes, you have said, brother.
And the Honorable The coordinate bench held it was pending. Now cannot say it was rejected. So finding on fact, it has attained finality. It says at the relevant point of time when 2001 came into force, that application was kept pending. Now, what's the legal effect of this? Pendency of representation during the coming into force of the notification.
Even if a 2001 notification, if we consider, then also 25 years are also elapsed, my lord. Because the allotment is of 1975.
Allotment is of 75.
Yes, my lord. And 2000, my lord, the allotment, time period goes, my lord.
How? They have filed the application on 96.
My lord, 96 when they have.
So 96, you have to you have to calculate that period from up to the date of his application. If you keep pending for 25 years, you say yes, that's over.
But as per allotment later, my lord, if they fail to, my lord, deposit the balance amount, my lord, then the, my lord,
they are entitled to a benefit of a circular. You could have rejected that earlier. You could have said no. But you waited for that. In the meantime,
only one fact I must point out. Lordship will kindly come to page 65, capital A. There was a capital A. There was a final notice for payment, which said that if you don't pay, it shall be automatically cancelled.
Yes,
but then
that was when?
That was not in 1980. But no, this point was taken by them in the previous round of litigation. His lordship held in the first round that since no formal order of termination was passed and the representation was pending, new circular came, so it has to be considered. That will not take away their right for consideration. That they have accepted. They have not challenged that.
Yes. Yes, Mr. Bandyopadhyay.
But today morning, my lord, we have received a brief. I could not go through the brief. Time, my lord. Today morning, we have received the brief. I could not go through the brief.
I have told it at the beginning.
Only one thing, Milord, let them not, our interim prayer is that let them not.
If I say so, Milord, Mr. Basu will, Milord.
No, because in the first round also there was an interim.
Taken steps. He is far away now.
He will give me, Milord.
No, he cannot do anything. He is far away now. You are set for this weekend.
I'm afraid of him.
Let them not.
When can you come back?
Please take the time.
Land manager.
10 days, Milord.
Let them not in the meantime not.
Do not allot this
Yes,
to anyone.
yes, Milord.
Mr. Bandyopadhyay is there.
By the
12, I am for the petitioner.
I am for the state law
Hello.
led by Ms. Juma Chakraborty, who is appearing.
I appear for the municipality, Kishnor Service has been affected. But this is matter.
The private party?
Private party has been served.
They have served. They have been
Received.
served.
Well, I have checked it up, it is received.
Yes.
Private party is the councillor of that ward. It is the municipality who is encroaching for the purpose of car parking in the views of encroaching the land of the PWD in front of us. But kindly see this
My
conduct.
lord, in this matter, I am appealing for
We are
state.
the owner of the some plots, residential houses are there. Now, in front of us, there are PWD roads. And in between, there are some plot of land covering the municipalities. What happened? In front of our house, the encroaching the land of the PWD, the municipality, because of the fact that the councillor of that particular ward itself, I have made her party, and my tender has been floated for construction of that, and her husband is the top tenderer, and constructing that. Kindly see the photographs. And adjacent to that, there are some administrative building, government colleges, CMH school, hospitals are there, ABTC road, only for the purpose of, my lord, heavy car parking, but the pedestrians and my other vehicles can be stopped by that. And if your lordship kindly sees the representation we have made, and I shall show some urgent photographs what they are doing this. Page 70 and
representation. What
page 74.
74.
70 and 74. Initial 70 and 74 also. And the administrator of that municipality is the SDO itself. And in the views of the
even this handwritten, this Xerox, nothing.
It's not legible. It's not legible. Page 70 also handwritten one.
Not
it was it was done hurriedly. Yes, I tender apology for it. It could have been made in typing. It should have been. And if your lordship kindly takes, kindly see, go through page 74. Entire statements are there.
Yes, what is your instruction?
Now, I'm showing one documents and photographs also. They are making car parking. Paragraph, third paragraph.
My lord, it's clearly stated they are prepared. They are just constructing that road on their own plots. It's a municipality plot, my lord. And they complied the due procedural measurements. Whatever has to be complied, they
994.
Yes.
My lord, my lord.
Well, kindly see the record of right. It's absolutely land owned by the municipality. Unless kindly see the photograph. The encroachment of the PWD is there. That car parking cannot be done. 16.
They are doing their on their own.
Yes.
plot.
Encroaching that. That is we are saying so, but it is no encroaching has been done. If your lordship kindly see, what is the floating tender of car parking?
Wait, let the PLRO do the demarcation.
My lord.
Where it is being done.
Let PLRO is not party.
Mr. বিশ্বাস, on which plot this encroachment upon which
entire ward numbers.
What is the plot number?
There are many plots.
Please give one or two name numbers of the plots.
Yes. No, there is no encroachment at all by the municipality.
Yes.
And PLRO is not made a party in the repetition. Let it be from the PLRO is not made a party in the repetition. Yes. That is
the PLRO.
And kindly see the record of right, lordship. Kindly see.
Record of rights is one thing, but the physical position may be otherwise.
Kindly see the photograph, page 59 onwards.
Photographs, it cannot be identified on which plot.
16 feet road.
Asking it will be for your benefit. It will be for your benefit. You will also know where the plot is there, where you are making construction. It will be for your benefit. Let a demarcation be done.
Yes.
Why are you opposing the demarcation? Is
No.
I think you should first come and say yes. Let a demarcation be made. Why are you opposing the demarcation?
No, I am not opposing.
Yes.
No, page 59.
Which plots?
Page plot number 1385. Then my lord 1401. These are the plots, all the residents of that particular area. Page 60, 61. Plot 1408. Dark numbers are there. Because 14 inmates are before your lordship.
Madam, how these instructions you have given, on what basis you have said that there is no encroachment? What is the basis of your this instruction?
My lord.
My lord, actually, as per our record, this plot is under us, under our periphery. My lord. That's why we are constructing.
Yeah, then
My lord, if you
no, I am kindly see the collision.
So, who is constructing?
No.
Is constructing. He is saying that we are constructing.
No. Where they are constructing, my lord, municipality is stating that SDO is the party. So we are clearly stating there that is our plot. So that is no encroachment has done. That is the main.
How do you ascertain encroachment, madam?
But there is some records, my lord. If your lordship
From the records, the encroachment, madam, from the records, the encroachment can be ascertained.
some specific plot number should be mentioned there, man. That's why.
By mentioning the specific plot numbers, encroachment can be ascertained.
No, my lord.
So how have you given the report? What is the basis of your report? That there has been no encroachment? How are you certain with that?
Sorry,
My lord, then the detailed report we can file.
That
My
there is
lord,
no
we can.
encroachment.
My lord, my lord.
Well, kindly direct the BLRO.
How can the SDO be so certain?
My lord, then BLRO should be added as a party then, my lord. BLRO can clear that point.
This is the tender process itself by the municipal.
Mr. Bishwas, if it is on their own plot, you cannot be agreed.
You cannot kindly see their statement in the.
Show me any material that there is any encroachment.
But let there be an investigation. Let it.
if Lordship kindly give the direction that PWD should be present, Lordship.
No, PWD road not over. Municipality road.
No. PWD is different, my lord. BLRO can only give that clarification, my lord. Whether that plots are under.
So your allegation is that the PWD road has been encroached.
Yes, in front of PWD.
No.
Can be.
The petitioner.
Matter will appear.
Let it appear under the upgraded motion or
Classification. Tomorrow I will mention a specific class, upgraded motion, that will be above in the High Court at Calcutta.
Matter will appear. Matter will appear on
18.
18.
Yes.
Yes, much obliged.
Yes.
In this matter, what
In the meantime, they are constructing. Some.
Let them construct. If it is encroached, it will be demolished.
That is my concern.
Now, my lord, what happened here, my lord?
No, I am for the Union of India.
The respondent authorities who are the railways, my lord, what are they doing? My lord, I am an owner of plot of land. My predecessor purchased the plot of land number RS Dag number 598, my lord, by virtue of a registered deed. Now, my lord, after being purchased, we are enjoying the property. My lord, there are shop rooms, my lord, which have been tenanted and some are belonging to us also. Now, my lord, these RPF personals of the respondents, my lord, have intervened into the possession, saying that you cannot do anything on the property, threatening us. Now, my lord, initially, my lord, we went up to the High Court, before this Honorable High Court. This High Court, after hearing all the parties, my lord, kindly turns to page 22 for once. My lord, 22, that's the starting of the order. Page 25 is the relevant portion.
Yes.
My lord will find the second paragraph in that view of the matter. My lord has got that.
Yes.
This writ petition is disposed of by directing the railway authorities to identify the land. It appears that the land belongs to the railways, surveyor to be appointed by the railway authorities. In that event, the railway authority shall be entitled to remove the structures. In case it appears the land belongs to the petitioner and he has title to the same, and the land does not belong to the railway, in that event the structure shall not be removed. Now, my lord, this is of the year 2000. Now, my lord, despite this, my lord, this writ petition was initiated on behest by us, our predecessor, pursuant to a notice issued, my lord, which is at page 21. Kindly see page 21 prior. My lord, a notice was served on us by the railways.
Yes.
Saying that on my inspection to the primary notice that such and such occupying railway land, measuring such and such. So, my lord, we approached this court. Now, my lord, this court passed this order to identify the land which belongs to the railways. My lord, they do not do anything. Now, my lord, they started disturbing. We again made a search.
Where is the notice asking you not to do anything?
My lord, page 21.
Oh, that was in the earlier occasion.
Yes.
No, now.
Now what happened, my lord? After this, they were again disturbing us. They do not take any steps. They do not measure the land. They do not send survey. They do not identify the land. Neither they say how they have acquired this land, how this land belongs to railway. Now, my lord, we were again compelled to come before this Honorable High Court. Kindly turns to page 31.
Yes.
Now, my lord, what happens, my lord? Kindly see the second paragraph. This court cannot go on for passing repeated orders. The order dated such as passed in the earlier writ petition is clear. If the petitioner has submitted relevant documents as proof with regard to his title, in that event, railway authorities are expected to comply with the order dated such as no
Yes,
further
Mr.
order
Mohammed,
be
you are
passed.
appearing for the railways.
For the railways.
What is your instruction?
But I have not yet received the instruction because, my lord, yesterday evening I got the brief. So, my lord, I will take some time, my lord. And, my lord, lordship, kindly page 31, my lord.
Yes.
If the petitioner has submitted on the relevant documents and proof with regard to his title, in that event, the railway authorities is expected to comply with the order dated so and so. So, my lord, whether they submitted their title, deed, and another thing to.
What is your instruction? They have encroached upon your property.
No, but instruction, it is a railway property.
What is the extent of the railway property? How have we ascertained that?
So that is
How much it extends? How far? Unless you decide your boundaries.
Yes,
How
correct.
can you
Yes,
decide the
yes.
question of encroachment?
So, my lord, it is absolutely correct, my lord. It is necessary to decide what parts of the belongs to the railway.
Survey. Have you made any survey? Pursuant to this, let them let me for the present accept your submission that they have not submitted any document. But that does not depend. Your area is not.
No,
dependent upon their
absolutely
submission
no,
of-
my lord, no.
They can create forged documents. They can create something.
Yes.
So you can identify your boundaries. Please identify your boundaries first, because you have to protect your property from encroachment. So please first come out. What is the extent of your property? What is the boundaries of your property?
Nothing.
Unless you come out with that, how can you say that someone is encroaching upon your property?
Yes, my lord.
And when the RCFs are coming, we are showing our title, the mutation, the orders of High Court.
But
Yes, we do not understand.
RPF is not authority, my lord.
No, no, RPF are police personnel of the railway.
RPF, if they are going, they must be under some authority.
For some authority they are coming.
So, yes, how
And
soon
my
can
lord,
you take instructions?
my lord, the petitioner made a representation in the year 2023, but they are silent.
No, have you communicated your decision?
So,
they have submitted, it's your duty to communicate.
I'm not when the RPF.
They will be silent because they are encroaching upon your property. They will only give us representative. They will sit tight. Show me that your decision that you have decided, you have surveyed, and you have ascertained this is the encroachment. Otherwise, you also cannot take steps for eviction. You are allowing encroachment, Mr. Bhumi.
So, Lord, only lordship I will take.
I'm keeping it on 17th. Please take instructions and.
With the direction, to produce all documents. With regard to how they become mentioning this plot, how they have acquired or how it belongs. But I want to know whether it belongs to me or not because I have a deed. But if they show it has been acquired, then I can take steps to that.
Your deed here.
Yes, yes.
Where?
But kindly turns me page 15.
Yes, Mr. Bhobik, they have annexed their.
They have annexed the BIB in this.
They have disclosed their document.
This is my mutation.
So, Lord, very well, my lordship, kindly give me 1 week time. I will take instruction.
18th.
18th
of February.
No, 1 week more. But lordship, kindly take 1 week. Today is 13.
Today is not 13.
No, sorry, 11.
I'm keeping it on 18th.
20th minute.
Exactly. You have said 1 week. I have given you 1 week.
But 20th minute. Because with the old documents.
You have said
but
1 week. I have given you exactly 1 week.
You knows very well the office of the government.
Hard with. On the same heading to enable Mr. Take necessary instructions. Service taken on. Yes, who is in this item? Yes.
Lordship, this is come under my instance. Lordship, due to urgency, your Lordship granted leave to move this matter today. Now, Lordship, I have served the learned government pleader and also served the parties also by hand.
But you are appearing
for the state, my lord.
Now, Lordship, this is regarding the ferry services, tender regarding ferry services.
Well, my preliminary objection is regarding maintainability before this honorable court. And it is reminded the land manual, my lord.
Yes, sir.
Part of the land reform.
No, Lordship, this is a tender matter. This is not under the jurisdiction of the West Bengal Land
Section
Reform Act.
281.
It's a tender under what provision? This tender is being floated.
Under the Ferries Act?
No.
No. Yes.
The Ferries Act.
Ferries Act.
Not as per the.
The procedure has been, Lordship, adopted under the manual. But the, Lordship, the tender which has been moot question of tender issuance of tender to the ferry services comes from the Ferries Act.
For what? Settlement. Tender is for settlement.
Settlement.
So the ultimate object is settlement. It comes under what provision?
Ferries Act 1885.
Show me. Whether it.
Well, the bids has been taken under the West Bengal Land Reform Act. It appears on page 35.
Page 35.
He has annexed, my lord.
Yes, this is tender document. I have to annex.
West Bengal Land second paragraph.
Yes, relevant rules of West Bengal Land Reform Manual.
Lordship, this is
the document on the basis
of land reforms manual, but Lordship, the purpose of this is a tender, not a land dispute. Tender.
Please kindly take up the land reform.
So many Lordship tender matters, Lordship, I have also Lordship the moved before this honorable High Court.
This point of jurisdiction was decided in those matters. Please show me.
Lordship, today is the opening of the financial bid.
You have to be ready with this maintainability because there are two divisions being
judged. Yes, my lord.
On settlement of ferries.
Yes, my lord. I am referring before your lordship, my lord. Bolo to.
Division being judgment on settlement of ferries.
1 minute Mothabari Dhibor Samiti. passed by this Honorable Court MAT 1363 of
By Justice Banerjee.
Justice Banerjee and Justice Apurva Sinha Rai and Abdul Oud. Reported in 2023, Milord, SCC online.
These are the division bench judgments binding upon me.
Lordship, kindly come page 44, which was
Sir,
the
please
subsequent.
answer the maintainative point first.
Lordship, so far,
Nullity.
I don't know whether Bengal Ferries Act 1885 has been considered or not.
Land reforms manual. This is under this notification says so. Where is under Ferries Act? It does not mention Ferries Act. It's under Land reforms manual.
No, here it
This is kindly come. Kindly come. This is the ferries and fisheries and other Lordship Sairati's interest. Lordship, this 266A.
See, please kindly come to page 35, paragraph 2. You are challenging this action against this. Please kindly come to paragraph 2. What does it say? It does not mention Ferries Act.
No. Lordship, this is Land Reforms Manual. The procedure there, it comes from the Ferries Act. Lordship, so far, Lordship, kindly.
Please see paragraph 2.
Paragraph 2 is the procedure. Lordship, this is the procedure. Lordship, and the procedure has been given by Rule 66A and Rule 281. Even if, Lordship, the Rule 281, the District Land and Land Reforms Officer
considered this division bench judgment.
No, Lordship, so far we have moved before obviously the Honorables, before the single judge, and Lordship, the matter, so many matters, Lordship, regarding ferries.
Show me that this point was decided.
Lordship, that was not.
The division bench has decided on settlement of ferries.
Lordship, kindly let them to, Lordship, they participate in the financial bid because my application has been rejected. Not only that, Lordship.
I cannot direct this. You are not understanding. If the maintainability point is raised, there is a division bench judgment. I am bound by that. So any order passed will be without jurisdiction. Please consider that.
Then Lordship, then today, Lordship, the last date of the opening of the financial bid. Financial bid today will be work order issued. Lordship, then matter will be becoming infectious.
Group 9
Kindly, I have challenged the tender. Lordship, kindly, even Lordship without jurisdiction. For the sake of argument that
saying without jurisdiction I can interfere.
No, Lordship, the DL and LRO has the authority to publish the tender. Kindly see this is the Rule 281.
Then
The LRO in derogation of Rule 281 issued the tender.
I cannot make myself clear to you. When I do not have jurisdiction in view of this division bench judgment, can I entertain, go into the merits?
Lordship, kindly make this matter tomorrow, Lordship. I will.
Please consider this because there are 3 decisions on this. One is in your favor,
yes, Milord.
But that has been held to be pari incuriam in this.
Yes, Milord.
One division bench is in your favor, I'm telling you. That has been held to be pari incuriam in this.
Yes, Milord.
After that, single bench, what can the single bench do now?
Lordship, kindly, Monday, Lordship, in the meantime, I will search everything.
Please consider this because Mr. Bandyopadhyay, please give those references.
Yes, I am giving.
You have the one which is also against you. No, you don't have. He will get that. Justice Mukherjee's order is the parent order.
Justice Subrakal
Mukherjee's order. So you will be getting that reference in this judgment itself. After some argument, the learned advocate. Next.
সব ঠিক আছে
কষ্ট করে
না এটা ট্রান্সফার করে নাও না চেঞ্জ করে নাও টেন্ডার হলে ওখানে চলে যাবে এখানে আপনি কেন তাহলে এখানে
Mr. Bandyopadhyay, next matter is yours.
Yes, but in this matter, Mr. Shondip Rai is appearing for the petitioner. He's on his legs in courtroom number.
Yes, sir, you are here. Yes.
But I'm praying for a short pass.
Yes, where is the report?
A report.
What is there, Mr. Bandyopadhyay? What is this matter?
তোমাকে কপি দেওয়া আছে তো হ্যাঁ দেওয়া আছে
Have you given a copy to him?
Yes, Milord, I have given.
What is the stand in the report?
My lord, your lordship kindly see the page 6.
Page 6.
Page 6.
Yes.
Similar land acquisition cases, similar project that has been challenged in another writ petition. My Lord Justice Jyotirmoy Bhattacharya passed the order, my lord. The proceedings can be. The second paragraph, my lord.
Yes.
Liberty is, however, given to the petitioner to take necessary steps for getting application transferred to the larger bench.
Why? What was the issue? Larger bench?
My lord, first paragraph. Since the court is informed by Mr. Pan, learned advocate for the petitioners, that intricate question of law which has been raised in this writ petition is now pending for consideration before a larger bench of this
What
honorable
was the
court.
issue?
Regarding the settlement,
Larger bench. Why
larger
larger bench?
constituted by the honorable Chief Justice due to difference of
What happened to
opinions.
that?
That is pending, my lord, till date.
This is in 2008.
Two different mandamus appeals and two different writ petition. Let hearing the petition. Liberty is, however, given to the petitioner to take necessary for getting application transferred to the larger bench. Taking up such matters so that application can also be dealt with by the larger bench. Next paragraph, my lord. It is made clear the proceedings for acquisition of land in question may be continued by the concerned land acquisition collector, but no award will be made in the land said acquisition proceedings without any leave of the court. It is already, my lord, completed, but award cannot be passed, my lord. We have stated in our, my lord, report briefly.
Yes, what can be done now?
But I am bringing
The report in the form of an affidavit.
But in terms of your lordship's earlier order, it is 17th of November 2025. But
Yes.
your lordship granted liberty to file supplementary affidavit.
Yes.
Lord, this is the supplementary affidavit we are filing. Having copy to the other side.
Yes, Mr. Banerjee, what is this matter?
No,
Again, both Mr. Banerjee.
I have not received a copy of the supplementary. It may be supplied to us. That
Mr. Banerjee, you have not given a copy of the supplementary affidavit.
Yes,
Yes,
I'm
a
for
copy to
KMDA.
Mr. Banerjee.
You are for KMDA.
You give a copy to Mr. Oyon Banerjee. Because both of you are Banerjee.
Lordship.
আপনি দিন একটা কপি স্ক্যান করে
আমি পাঠিয়ে দিচ্ছি।
স্ক্যানও করুন
The Banerjee, you are for the state.
I'm for KMDA, man.
I am appealing for the state.
You are for the yes, Mr. Banerjee. what is the-
একটা কপি ততক্ষণ আমার কাছ থেকে নিয়ে নেবে।
দেখে নিয়ে দিয়ে দিচ্ছি।
দেখে নাও।
দেখে দিয়ে দিচ্ছি।
Lord, your lordship kindly
It's a report.
at page, but previously there was an order of the writ code, page 49.
Please give me the scope of this writ petition, thereafter I will go through.
Lord, the scope of the writ petition is, Lord, that acquisition proceeding was initiated
Under?
Acquisition proceeding under Act 1, 1894 was initiated for the purpose of flyover, Salkia flyover. That has been abandoned. Now, Lord, this is for the purpose of market, construction of a market. Now, Lord, ultimately, no compensation was paid within a period of 2 years in terms of Section 11 capital A. Therefore,
It
by
stood lapsed.
stood lapse. And secondly, my Lord, at the first, when first writ
But
petition-
property utilized.
property was not utilized, possession was not taken. We are in possession. Then, my lord, what happened? That thereafter we filed a writ petition challenging this acquisition proceeding on that ground, and alternatively we prayed that a scheme has been framed that alternative accommodation will be given. under the
There was no
Howrah
scheme.
Improvement Trust Act. Lord, that scheme has been published also in the newspaper, in the newspaper. Lord, we said alternatively that may be given. Lord, we are interested with regard to, Lord, either you are to proceed on that basis or alternative accommodation. No compensation was paid also. Then 24(2) subsection 2 will appear. Now, Lord, question would be, if some of the co-sharers got the compensation, then, my Lord, that would be deemed to have been paid to the other co-sharers. Therefore, that ground we cannot. Our case is that none of the
co-sharers have been paid.
None of the co-sharers are paid. Our case is none of the co-sharers are paid.
Paragraph 12.
Now, Lord, according to, my Lord, page 49, that liberty was given that if settlement was made, then settlement for to make compensation is made, then, my Lord, in that case, the settlement be concluded, and accordingly with liberty that if no settlement is concluded, then on the same cause of action, we are given liberty to file a writ petition. Now, my Lord, what I have supplementary affidavit, we are stating that they have already prepared an appeal against the order dated 21/12/2017.
Who has prepared an appeal?
They have prepared an appeal.
They means KMD.
Yes. Prepared
What
an
happened to
appeal.
that?
That is pending.
An appeal with an application 2,400 something days delay. But that is pending. But that fact was not spoken in my writ petition, which I submitted before your lordship, that would be an suppression of fact. Therefore, I may be permitted to file a supplementary affidavit. That is why your lordship granted me to file supplementary affidavit. Now, Lord, this can be adjourned for fortnight so that, Lord, the fate of, because we have to mention that matter. Because in the event, my Lord, this appeal is disposed of by setting aside this order, then, my Lord, my right to file a separate writ petition on the same cause of action goes. Then second writ petition on the same cause of action goes. That is why I am submitting. Am I clear to your lordship?
Unless that previous chapter is concluded, will not possibly cause of action for the present, it will not lie.
Yes.
So let the appeal. What
that is.
the learned senior advocate is saying,
That is, I am
agreeable to that.
Your Lordship, prior into consideration the report.
What does it say?
Your Lordship, it says that everything was completed. Award has been given to the paragraph 12 persons that the petitioner have mentioned. Your C's paragraph 12.
11 capital.
12. Paragraph
12. Paragraph 12 of the writ petition.
Of the writ petition.
Writ petition, they have mentioned the names of their ancestors. And in this award list also, though I have just received the report right now, your Lordship would find as circled some portions. I beg your pardon.
Dulal Chandra Das.
Lordship.
No,
No,
that
they are-
is with regard
they
to
are
other
ground-
property not covered by the notification.
Krishna Chandra Das.
Therefore, he can file a
They say 11 shall be attracted because it was not paid.
Because
But that
it
is not
must
the
be-
section. If
must
award
be
is
covered.
declared, then 11 will
Present
not
position.
apply.
Not because it must be covered under a same notification. This is other property.
Alright,
Co-sharers-
he prays that since the appeal is, he wants to an adjournment. Mr. Haradan Banerjee,
11
learned
হবে না।
advocate,
Lord, supplementary affidavit file with check.
Supplementary affidavit taken on record.
Taken on record.
You have served the copy. Copies
the
of the
copy.
supplementary
One copy,
affidavit.
my lord, is to be served
1856,
to-
2000.
One
Taken
copy
into
is to be
consideration.
served to Mr. Kaur.
What?
Report, the report filed by the.
Report I have taken on record.
Mhm.
Supplementary affidavit you have got.
Your lordship, we have received.
Supplementary affidavit. Who is appearing for the petitioner?
My lord, I am appearing for the petitioner, my lord.
Yes. Yes.
My lord, this matter pertains to the conversion of my land from industrial to residential. My lord, am I audible, my lord?
Yes, yes, you are audible. Where is your application?
My
Where is
lord,
your application, madam?
It is from page 84 to convert my land and to convert my land from industrial to residential, because my partnership firm was dissolved on 2011 and we are the owners of the land. But despite, my lord, several representations, nothing has happened, my lord. Till date, we are in a
Yes, Mr. Bandyopadhyay.
Conversion, how matter relates to conversion from one class to another class, my lord.
Yes, madam. How a writ petition is maintainable?
My lord, may I, my lord, my lord, in this matter, there were two authorities who were to make inspection. One, land department, another is my labor department. Now, my lord, for the labor department to cause an inspection, my lord, how can I approach any other authority? And there is no rejection order. In my case, where the conversion case has been rejected, they have to consider it, fix a schedule, my lord, for the inspection and take a decision whether the land to be converted or not. And after that matter, I could approach the appropriate authority if that comes to a negative.
But your prayer is for conversion, to issue conversion certificate.
Yes, my lord.
Are you not pressing that prayer?
Yes, my lord, because as of my lord, if the state respondents are, my lord, agreeable to cause an inspection on a specific date and take a decision in my respect, I have no other prayer as on date.
Which authority will cause an inspection? Which authority will take a decision?
My lord, respondent number 4.
Respondent number? Respondent number 4. So for the present, you are not
Yes,
pressing
my lord,
your prayer for. Sir, for the present, you are not pressing your prayer for issuance of conversion certificate. I shall record that.
Kindly don't records that. Kindly makes it an order of the court that the respondent number 4 shall cause an inspection.
If you say that for the present your prayer is not that, I will record that and I will limit you this writ petition only for causing inspection and for giving no objection certificate. That after you take an instruction and say you are not pressing for the present the other reliefs. Because that's the parent.
May I come back tomorrow then? May I come back tomorrow then, my lord?
For what? For what?
My lord, this prayer, no, this stand that the writ petition is not maintainable at this stage.
That the ultimate relief which you have claimed that can be granted by the Land Reforms and Tenancy Tribunal. So if you say no, I do not want that, I will record that and I will direct only to issue a no with regard to the NOC. I will direct them to consider. But then I have to record that you are not.
That. My lord, as on date, I am not pressing that. As on date, can you record that too, my lord? That too. That will save my.
In the writ petition, you will not be pressing that. I will record that.
My lord, record, sir.
Mr. Bandyopadhyay, then you take instructions by.
I have taken instruction, my lord.
Yes.
My lord, your lordship kindly. My lord, your lordship kindly see.
Yes.
Page 7, my lord. Page 7 of my report.
Page 7.
Page 7.
Yes.
My lord, I am reading. Matter pertaining to application for conversion of land from VT Karkhana to housing complex, Mouja such and such. With reference to, I am directed to inform that LR plot number such and such district with the purview of the section 6(3) of the West Bengal Estate Acquisition Act 1953. I am therefore directed to
After obtaining NOC from Labor Department.
my lord. Thereafter, my lord, we have informed my lord the Labor Department.
Yes.
Next page, my lord.
Yes.
But it is page 9, my lord.
Yes.
It has been sent by the Assistant Secretary Government of West Bengal to the Deputy Labor Commissioner. I am sending here with a letter such and such. Make necessary arrangement, inspection, and submission of the viability report in accordance with the SOP issued by the department in this respect from all aspects regarding conversion of land.
So, what happened? What did the Labor Commissioner do?
I have not received any instruction.
So, I'm directing the Labor Commissioner to
Milord.
take a decision. I'm restricting his prayer with regard to
Milord.
that only. Yes, sir.
Yes, my lord.
Uh, when the attention of the
My lord, I am for
এটা
petition.
করে দিন। It is
Lordship.
At the very outset, Lord, I think.
Lordship, against the illegal encroachment of the public road, causing obstruction of ingress and egress of my client.
At the very outset, Lord, I tender.
Copy of the report has been served till date, Lordship, in spite of order passed by your Lordship.
Lord, at the very outset, Lord, I'm tendering apology, Lord, because it's my fault. On 11th of November, your Lordship has been pleased to direct him, Lord, the engineer, executive engineer, PW department to file an affidavit. Lord,
Report is not ready.
indicating the report. Report has been filed. It is my fault, Lord. It's not made ready. Kindly give me 7 days time and I'll come back, Lord.
Mr. Banerjee, learned advocate,
Deeply obliged, Your Lordship.
call the next matter.
Deeply obliged, Your Lordship, for accommodation.
Thank you, Mr. Banerjee. Yes.
The petition.
Yes.
This is with regard to Lord.
My lordship, I am for the ECL candidate.
I'm appearing for the ECL authority, my lord.
Lord, acquisition of land by Lord ECL, not Lord under the LA Act, by ECL for Lord expanding coal mining activities. Now, Lord, there was a.
I could not follow.
I'm sorry. I'm sorry. Lord ECL, Lord, Eastern Coalfields Limited, Lord, they have a land losers policy scheme, which says that Lord, prior to 1985, whichever land was Lord acquired or used or utilized, whatever. Milord, for those land, Milord, they will provide employment in 1:1 ratio, meaning thereby for every acre of land, Milord, one employment would be generated. Post 1985, Milord, they changed the ratio. They said, Milord, now they will go by 2:1 ratio for every
one employment.
One employment. Now, Milord, our land was taken, it was used, Milord, those are admitted positions of fact. There are so many documents, Milord, to show that that is an admitted position of fact. Milord, we are not given employment. This is Milord second round of litigation. Milord, the first round travelled up to the
land
honorable.
loser certificate is there.
Milord, that our land has been acquired. There is Milord no dispute with regard to that. I just indicate Milord what happened in the first round of litigation. Milord, we succeeded in the first round before the honorable single judge.
What was the relief paid in the first round?
Employment only. The relief Milord, that we have prayed here also.
What was the order passed?
Milord to treat us as land losers and Milord to deal with us accordingly. That was Milord initially the order passed by the honorable single judge.
Treating you as a land loser.
Yes. Then Milord, they travelled up to the Milord honorable division bench. Honorable division bench, Milord, affirmed the order passed by the honorable single judge.
That order was not modified.
Ultimately, when it travelled up to the honorable Supreme Court, Milord, the honorable Supreme Court directed that Milord, we should make a representation. Milord, we have made that representation. Now, Milord, on the basis of the representation, Milord, they have passed a so-called rescind order, which is under challenge here. Milord, in the rescind order.
According to you, the order is captioned as one rescind order, but is bereft of any reasons.
That's Milord how I look at it. Now, Milord, the order says that Milord, we did not have 2 acres of land. So, Milord, we are not entitled to Milord any employment. Why they say so? Because Milord, we as a whole, as a chunk land for Milord 6-odd acres of land, Milord, we had asked for 3 employments. They say they cannot, Milord, they will go by Milord parcel of land basis and they will not go Milord on a package deal basis. Whereas, Milord, in the previous documents, in the circulars, in the communications, in the orders passed in the first round of litigation, everywhere they said that, Milord, there is a.
The dispute now. Person or a family or
4 persons having 1.5 acres of land.
If a group of persons or a family owns 6 acres of land
together,
so they will not be entitled. According to you, you will be entitled to 3 employments. according to them, you will be entitled to one employment.
Not even a single employment, because they say, Milord, each of these individuals did not have more than 2 acres of land parcel wise. They say we cannot bring all the lands into one single pool, which is contrary to their own policy.
But in a way, Mr. Banerjee, your claim is admitted that if let us take 6 acres for the present, so 6 acres. So if each of you has two acres,
Slightly less than 2, slightly more than 2.
no, then if it is at a body, Mr. Banerjee, then you cannot say each one will be may have less than,
Milord, may I put
because
it?
if you say 2 acres, one employment each, then the person entitled has to have 2 acres.
I'll
But
show,
if
Milord,
you
that.
say no, as a body, then
Milord, I'll show your lordship that, Milord, the
show the
policy says
notification
otherwise. Yes,
or the circular,
definitely.
whatever it is.
Definitely. Milord, before, Milord, I show your lordship the circulars, Milord, I put it, Milord, in a simpler way.
Please show me the reasoned order first.
Yes.
That's at page 170, my lord. Page 170.
This happens when the two Mr. Banerjees appear against each other. This happens. So both of them want to get a first right of audience.
No, my lord. I was only responding to my lord's call.
Yes, yes. Which page?
Page
170. 170.
Yes.
And the relevant portion will be 171. Bottom.
Mr. Shiv Shankar Banerjee, allow Mr. Siddhartha Banerjee to make his submission. It's his petition.
I'm sorry, my lord. I
They
thought I
show
have only
some
one
other
is more
portion.
than him. I am
They show
SS
some
Banerjee.
other
He is S
portion.
Banerjee. I thought only one is more than him.
Oh, S Banerjee. So first is also same.
Yes.
Yes,
Milord,
yes.
page 170 is, Milord, the order.
Yes, 170. Yes, Mr. Banerjee.
Kindly take, Milord, the third paragraph onwards at page 170.
Yes.
Subsequently, before that it says, Milord, orders were passed by the Honorable Court, representations were made. Now, subsequently, the applicants were called on for a personal hearing on 17th February 2025 at the office of such and such. During proceedings of personal hearing, the applicants reiterated the stands taken in their representation and sought for 3 employments. It is pertinent to mention that the Honorable High Court at Calcutta, vide its order dated such and such, title such and such, directed that the applicants be considered as land losers and treated accordingly. Further, upon appeal filed by etc., Milord, I do not trouble your lordship with that. Kindly then take the reason starts, Milord, from third paragraph of page 171. The policy of 2001 postulates that employment opportunity will be provided a parcel of land from 2 acres and above purchased by ECL. Milord, this is wrong factually. Upon perusal of the documents submitted by the applicants and examination of the same and in accordance with the land looser policy of 2001, the following details are observed. The applicants have claimed that they, along with other co-owners, are the owners of the land situated appertaining to RS plot number such and such. Details of the land along with their shareholdings are mentioned in the chart below. Then kindly see, Milord, the second column from the left-hand side of the chart. Quantum of land sold by the petitioners, Milord, they are showing it as if, Milord, for the first petitioner is 1.65, for the second it's 3.30. Deed-wise, Milord, going. Next is 1.65. In the present case, as is seen from the chart reproduced, each of the petitioners have sold less than 2 acres. In case of Mantuchel, the land share work out to be 1.10 acres. NOC or consent from other landowners have not been provided. Again, factually incorrect. So, Milord, there are 2 foundations. Milord, I'll come to that. Milord, may I just complete my reading? The land holding of Manik Maji works out to be 0.55. Ranjit Maji 1 point such and such acres, which is below 2 acres. A reading of the policy of 2001 establishes that employment opportunity will be provided to a parcel of land from 2 acres and above purchased by ECL. Based on the above documents and the land holding of each of the applicant, it is concluded that upon the perusal of the above mentioned chart and policy, it is clearly established that the land acquired from each of the said persons or applicants is below 2 acres, which is determining factor for offering employment. Clause 1 of the policy specifically mentions employment against 2 acres of land taken from the landowner. The ownership should be absolutely free from encumbrance, etc. Since the individual land holding of each of the applicant is below 2 acres, applicants are ineligible for employment in accordance with the policy. It is also a fact that the applicants have been paid land value for purchased lands, neither here nor there. In view of above and the fact, the application, the representation is rejected. So, three
That
things.
policy once.
Yes.
Because one part has been quoted. Please show me the
Yes.
entirety of the.
Kindly,
You
have
have
a
the
look
copy of
at.
the policy.
Kindly have a look at page 61 once. I'll quickly take your lordship to the relevant portions. Then, I will show it.
61 or 161?
Only 61. 61.
Yes.
This is their internal correspondence.
No, I want to see the policy.
I'll take your lordship. I'll just show how the policy has evolved.
If your lordship allow me, I can use a affidavit disclosing my relevant policies. So far, I have been not called upon for filing affidavits.
Yes, Mr. Banerjee.
19th April 2000, internal documents. Kindly see who the author was. Personal manager of ECL. Writing it to the agent of ECL. It may kindly be noted that Mr. Jalal, etc. had earlier made a representation in respect of employment of Ranjit Maji, the petitioner before your lordship, and 3 others under land loser scheme against the acquisition of land of Jamdia Mouza for mining purpose. It has also been confirmed by Mr. Jalal that compensation payment had already been made to the land outside, but the employment file was not yet processed and it is lying pending at the colliery for a considerable period. Then Millard assumes importance. The total land acquired under package deal, that is 8.25 acres, on condition that 4 employment would be provided. Therefore, said land was required in the month of December. It should have been acquired possibly. Competent authority desires to have the detailed report about the land matter. So, they are admitting that the policy postulates or contemplates a package deal. Now, what the package deal is, kindly then have a look at page 74 once.
Yes.
This is possibly the policy which my lord was looking for.
2001 policy.
Yes. This is a document of 26th of August 2001. May I skip over the first paragraph? The subject is policy with regard to dealing with the cases of providing employment opportunity to land losers. That we are land losers is no more in dispute. Second paragraph. ECL board in its 164th meeting held on 10th July 2001 at such and such has directed the following, which will be serving as a strict guideline for compliance while handling the cases of land losers. The project schemes which be of self-financing nature, etc., that is without creating any extra burden on the existing cash flow of the company and keeping the recruitment to the barest minimum, the company may go ahead towards recruitment of land losers by accepting the following guidelines. Then what they quoted is the first paragraph. 1 employment against 2 acres of land taken from the landowner. The ownership should be absolute and free from income runs or litigation. Land should be taken in possession of the company before the time of offering employment. A maximum 2 employment against land under 1 ownership would be admissible where land holding excess 4 acres. Then, in package deal, landowners having less than 2 acres of land may be permitted to tag his land with other landowners to make it 2 acres for claiming 1 employment. In such cases, all the landowners will have to forego the right of monetary compensation that we have done. Tagging will only be permissible if the landowner holds land within the same package covering the same area. All such landowners will nominate only 1 person for offer of employment opportunities. We have done so. No tagging of land will be allowed for land which has already been acquired and belong to the company. Company means Bengal Coal Company prior to State Acquisition Act. That is neither here nor there. Age will be below, these are not important for our purpose. Kindly turn over the page. Can you see the next page, then the last two paragraphs? Even the old cases where the land has been damaged due to mining operation, that was our case. The above policy guidelines will be holding good. Any negotiation, therefore, must be limited within the prescribed guidelines and as per the directive of the board. It is addressed to emphasize that the R&R policy, rehabilitation and resettlement policy, and directives issued by Government of India, the land losers project affected people may be persuaded to accept monetary compensation. They can make a request to us, you take money instead of asking for an employment. But the prerogative would be mine. They can persuade me. So, my lord, this was the policy as a whole. They quote only one paragraph selectively. My lord, makes no whisper about the package deal. And now they are trying to say that under 3 deeds, my lord, the land was sold. They say, my lord, the vendors sold to my lord ECL. Now they are trying to say that, my lord, under those deeds, each of the vendors had, my lord, less than 2 acres of land, without at all referring to, my lord, these clauses. My lord, this was.
How much time you will take, Mr. Ban?
I'm sorry, my lord.
How much time you will take?
My lord, may take some time, my lord, half an hour to 45 minutes. My lord, I need to show, my lord, some documents. My lord, this is a fraudulent, my lord, denial, my lord, of our entitlement.
But Lord, I'm sorry, Lordship, in this case, I need to use an opposition, Lordship.
Last
Otherwise,
day, Mr. Banerjee's submission was he does not want to, my lord, use an opposition because, my lord, everything is on record and it's an open and shut case.
No, that's right. But then after receiving his.
Sanko Banerjee, what for do you want affidavits to be filed?
Can't
Because
improve.
you have to only support the reasoned order. You cannot improve that by way of filing an
No,
affidavit.
Lordship, what I'm saying, the supplementary which he has disclosed, Lordship, I am not going to input.
But I'm not showing, I'm not relying upon the supplementary affidavit.
Because my company.
I'm not relying
Mr.
upon it.
Banerjee, you cannot improve upon from your reasoned order.
No, Lordship. What I'm only saying is the document which he has brought on record, other policies and clarification subsequent thereto, if I bring it on record, that will.
But that has not been considered in the reasoned order either. If you say so, I am setting aside, I am directing you to reconsider this.
This will go on and on then, my lord.
Then Lordship, if your Lordship kindly see also page 77, Lordship, there is one clarification in 2003. If your Lordship kindly comes to page 77.
Banerjee, that's not the ground. Clarification has not been taken into consideration.
No, Lordship, what I was trying to say is.
You stand or fall on the reasoned order itself.
True, Lordship. If your Lordship kindly come to page 77 once, Lordship.
Yes.
That was the next document, my lord, I would have, my lord, shown
If
to
your
you.
Lordship, yes. If your Lordship kindly come to page 78 middle.
Then
I'm just for an example, I'm showing this. Lordship, the package deal, which was there earlier and what will be there thereafter.
The other matters are fixed.
At 2 p.m. I also have, my lord, a prior professional commitment. My lord, I may not be there, my lord, at 2 p.m. Any day which otherwise is convenient to your lordship.
If your Lordship allows us.
Same heading.
Very well.
What I'm saying, Lordship, if your Lordship keeps it after a 10 days or so, and Lordship, by that time, I can just bring on those documents on it.
If you want to prepare that, let it appear. Mr. The supplementary leave was done.
I'm sorry, my lord, I'm sorry.
The thing, when a date is suggested by the court, there will be an opposition from that side. We've agreed to that, but after some objection.
I
Lordship has fixed on which date, Lordship?
24th.
24th.
Great.
To trouble your lordship again. Your lordship, this morning I mentioned a matter regarding conducting of a peaceful rally on the 16th, that is the upcoming Monday. Lordship directed me to give the date in the presentation form and file in the department. Lordship, I went to the department. The department is unwilling to give me a date before the 16th unless there is a writing of the court. The 16th is Monday, your lordship. The last working day will be Friday. The department.
My lord, I appear for the applicant. This application has been
For state respondent lordship, very unfortunate to mention lordship that no notice for upgradation has been served upon us. Suddenly I find it in the today's list.
Lord, I have been told, Lord, the
My lord, we had
matter is being
mentioned
mentioned by the National Highway.
notice was served upon them.
Stateর এক্ষুনি কিছু বলারও নেই।
I
And
also
answering respondent is not also the state.
Paramita Banerjee,
my lord,
you have mentioned this matter.
my lord, my lord,
Have you notified the other side?
my lord. We have.
Where is the notice?
This, no, the application that I also have an affidavit of service of the application, my lord,
What application?
of the CAN 1, my lord, party file.
Learned advocate. That you have mentioned this for upgradation. Have you given a notice to
Absolutely,
the
my
other
lord, we have.
Show me that.
Can it to কোনো কপি পাইনি আমরা?
এই তো সার্ভিস করা হয়েছে আমার affidavit of service এই তো ও পেয়েছে
আমাদের স্টেট কপি কোথায় আছে?
Where is the notice?
But the copy is being served to us, to the petitioner, the CAN application for addition, with
CAN
the
application.
intimation that they will mention the matter that we have got, the writ petition. But I do not know whether the learned advocate for the state have received or not.
Lordship, CAN application has also not served.
my lord, I have the affidavit of service showing served.
স্টেটের হয়ে কোথায় দিয়েছিস সাত পিক দেখতে পাচ্ছিস
আমাদেরকে মেন পিটিশন রিট পিটিশনটা আছে।
এটা কি সুপর্ণা জানাটা আমাদের স্টেটকে কোথায় দিয়েছিস এটা
এই তো জয়েন্ট সেক্রেটারি স্টেট অফ বেঙ্গল বাই স্পিড পোস্ট করেছে
স্পিড পোস্ট করেছে ওই জন্য
কপি পাইনি।
They send the state authorities but through speed post,
not GP service. GP service.
তুলি তোর কিছু বলার
What is this matter?
CAN এর একটা
But
কপি
the CAN application is basically National Highways Authority wants to implicate themselves as one of the party respondent in the writ petition, which is necessary. My advocate on record done the mistake.
My lord,
that your lordship can allow.
Yes, what is this main
This
matter?
main matter, my lord. 3G, my lord, if your lordship straight away comes to page 82 once, my grievance is very limited.
Anyway.
My lord, now the law is settled, my lord, after the notification of the central government. Now, the 4th schedule of the 2013 Act, my lord, the National Highway is being incorporated. If that is being incorporated, then whatever the calculation that has to be done as per 1st schedule of the 2013 Act. Now, my lord, 3G lays down a procedure. My lord, I know after 3G, my remedy lies before the arbitrator. That, my lord, I know. But page 82 is, my lord, my grievance is that straight away, I have been notified page 82. I'm just taking one of the instance. There are other petitioner, my lord, the court fees have been paid. My lord, I have been notified this amount which will be remitted to my account. My lord, my grievance, what if the award? My lord, I say, my lord, as per the law, this cannot be an award. This is a notice. A notice, my lord, intimating the amount. But, my lord, if the bifurcation is not given, how can I, my lord, know that the 1st schedule is being applied properly or not?
what grievance, Lord, I should ventilate before the arbitrator, because my forum is not the writ court. But I just want to know the bifurcation. Let them provide me that, I will go.
But I
Very
have
well.
one objection in this case. First thing is the repetition is maintainable and on. According to the 2013 Act, Section 74, it is very much clear that repetition must be filed within 60 days from the date of the passing of the award. Can you look at the Section 74, 2013 Act? Appeal to High Court. Repetition filed 3rd September 2025.
Section 74.
74. But appeal to High Court. The requiring body or any person agreed by the award passed by an authority under Section 69 may file an appeal to the High Court within 60 days from the date of award. When a repetition file, can you look at that? 3rd September.
It's not an award under 2013 Act. It's an award under 3G. Modalities of 2013.
That they are advanced only for that according to the award passed 3G 1956 Act. But appeal is filed 3rd September 2025.
This is an award under which act?
Award under?
This is an award under which act? The award which is challenging is under which act?
1956 Act.
So this is an award under 2013 Act. The award has not been passed under the 2013 Act. This is not an award under 2013 Act. But only the principles of computation that has been applied. Not all the provisions of the 2013 Act. Because a separate procedure under 3G, 3H has been incorporated in the 1956 Act. And a different procedure under the 2013 Act.
Competition to state court.
So when the award is under the 56 Act, he has to follow the 56 Act procedures laid down, not 2013 Act. Only for a limited purpose, this National Highways Act has been incorporated in the 4th schedule, I think. Only for the purpose of determination of the compensation, not for other provisions. So these provisions, how it will appear, apply the here?
Page 82, the award was.
Is it an award? Can it be said to be an award?
No.
I'm setting aside this award. What's a fresh award? He only wants the
computation. Nothing else.
Quantification. You are raising the point of mentality. I'm setting aside award. This cannot be said to be an award. It does not come within those four corners of that award. Yes. You are for whom?
Union of India.
Oh, Union of India. Yes.
National.
It's you who have prepared this award. Determined. Can you furnish the calculation?
A short time will be required, Lordship. Lordship, I am having one instruction, but that will not suffice, I think.
Instruction. He wants only the calculation.
Calculation is not here, Lordship. This is the determination portion is given over here. Lordship, though it is marked, Lordship, in the second page, the 3G determination of amount of payable as compensation.
আমাকে একটা দেয়া যাবে?
Of award.
Lordship, this is the whole tab.
Mr. Mukherjee, this 4th schedule is what?
Lordship, this is the whole tabulation which I am having.
List of enactments relating to such and such.
Lord, 4th schedule only the list of
105
enactments.
Is 105. 105 says subject to subsection 3, the provisions shall not apply to the enactments relating to land acquisition specified in. So subsection 3 says the central government may by notification within 1 year from the date of direct that any of the provisions of this act relating to the determination of compensation in accordance with 1st schedule.
That notification should have annexed.
Revision and Settlement Act specified in such and such being beneficial to the shall apply to the cases of land acquisition under the special or shall apply with such exceptions. Now, this is compensation will be first schedule.
First schedule, Milord. First
So
schedule,
first
kindly
schedule
see.
says
Section 32, according to section 32, the components are being, Milord, mentioned in the tabular statement. এটা তো ওরা ক্যালকুলেশন না দেওয়া পর্যন্ত আমরা কিচ্ছু বলতে পারবো না। Of section 3G that also suggests that the competent authority, while drawing up the award, has to consider what is the market value he has arrived at. There are A, B, C, D, 4 components given under subsection 7. And it starts with both the competent authority or the arbitrator. Arbitrator comes, Milord, after, but the competent authority is the authority under section 3G 1 and 2 who is determining the award.
so market value, damage, this and this thing, and
these are factual component, Milord. And the
Yes.
other component is first schedule. There are statutory component also. So nothing is being informed to me.
yes, how are you determining the compensation?
Lordship, kindly come to the, as per instruction, I'm stating, Lordship. Lordship, that estimates of the acquired land in every LA case has been prepared on the basis of the market value determined as per provision of NH Act and section 26
So
of
NH Act is 3G7.
Lordship.
So show me that this award contains that specifications, those breakup.
Lordship, kindly come to Lordship 3G7, Lordship, the competent
Yes.
authority or the arbitrator while determining
Both competent authority under 1, arbitrator under 7.
Lordship.
So here we are on competent authority.
Lordship.
So these are the components, and this compensation has to be computed in accordance with the first schedule, because the provisions relating to determination of the compensation shall apply.
Lordship.
So if it has to be, please kindly come to the first schedule.
Page number 82.
So market value, you have to decide on that basis. Thereafter, you have to apply the first schedule.
Lordship, as per Lordship, section 3G5 of NH Act, Lordship, there is an alternative remedy open to the petitioner or applicants for the, that is a toward to the arbitrator. So if they anyway grievances with any of the things, they
Madam,
can
only
be.
one thing, what is the object behind passing a rescind order? We have considered those line of decisions where in the municipal assessment, the valuation of increase of valuation, only the rate chart was on the rate that bill was given. Question cropped up because that's an appellable provision. So whether they have to be relegated to the appellate authority or writ is maintainable. So it has been held, no, this does not contain how this was arrived at. You have to supply the reasons. So you have computed. The basis you have to indicate, otherwise how can you challenge?
Lordship, as per the schedule.
So only in an order, if one line order is passed, writ petition is allowed, writ petition is dismissed. Can you challenge that order? On what ground you will challenge that?
Lordship, here as per
That's
the.
same. You have only given this is the amount. But how have you arrived at? What's the basis? Unless you indicate that, how can that be challenged?
Lordship, I'm handing over. This is there.
What is that?
Lordship, that is the determination. How the determination has been made. Lordship.
Please show me how the determination. You can give the copy to Mr. Mukherjee. Then he knows.
Lordship, then then have to file the report, Lordship, because this is in a very haphazard way it's given. So it's very much.
Do you have a computation sheet?
No, this is not the computation sheet. Lordship, this is the Shali private land and how much.
Oh, that's the classification,
yes,
valuation,
yes.
market rate.
Yes.
What have you have got from the market value?
Lordship, kindly
That's one thing. But
yes.
the basis of this calculation, these ingredients, damage, whether it has been done, not, consequences of this shifting and other things, you can say yes, no, no incidental charges, all aspects, components you have to indicate.
Lordship, then I have to take a report, Lordship. And this
in all matters, this
is happening, my lord, everywhere.
And this thing I am having, that is of the land, that's a private land or Shali, and that chart.
Yes, anyone leading you in this matter?
Tapan Mukherjee, sir.
Where is Mr. Mukherjee?
Mr. Mukherjee is engaged in court.
Ask him to come. Call him.
Lordship, pass over then. Lordship.
Yes, I'm passing it over. Ask him to come. Madam, please take this report because please file it on that side. Yes. Who is for the state?
Mr. Banerjee and Mr. Ramchandra Guchait appears for the state.
Yes. Yes, what is this matter?
Malad, if your lordship kindly turns to page 19, Malad, this is my application made to the divisional officer, raising an allegation that Malad, just in front of my house, Malad, a construction.
Subdivisional officer is under which act?
Malad, subdivisional officer, other officers, your lordship kindly turns to Malad, page 20.
This is a government land.
Government land, but
what provision, which statute will be applicable?
In this event, Malad, I have tried my level best. I cannot ascertain, Malad, to which Malad authority it belongs. And that is why, Malad, I have made it in this way. If your lordship kindly turn to page 20. No,
page
20, 20 and 21. I have sent it to all other possible authorities, Malad, whom I have thought it to be, Malad, correct.
Now, please tell me whom to be directed.
Malad, the state, me, Malad, because I am not sure whether
the state does not appear. Let us assume state does not appear. You have to stand or fall on your own case.
But in that event, Malad, subdivisional officer may be, Malad, because Malad, subdivisional officer has also an independent.
Under what provision of law?
Malad, in 133 of CRPC also, Malad, he has a power. Malad, all of Malad, exercise of these special laws.
133, which authority has the power?
subdivisional executive, as an executive, exercise an executive power. All these orders passed by different authority ultimately goes to the subdivisional order, and subdivisional officer ultimately exercises the power under 133, and he has also independent power also in 133.
Yes, where is Mr. Banerjee?
My lord, Mr. Banerjee has left the court due to his personal difficulty, my lord.
In many of the cases, Malad, we get confused because Malad, once we make application to one authority, after inspection, it is found that it belongs to some other authority.
The petitioner alleged
affidavit of service in respect of repetition and mentioning.
391, I am for the petition. I have not mentioned this matter, my lord.
Item number
291.
Yes.
I have never mentioned this matter, my lord. It was appearing in the monthly. Suddenly, my lord, I was informed today by the private respondent and advocate the matter is appearing before your lord.
The difficulty is, Lord, we have mentioned upon notice. My junior has given them an email.
Legal notice. They are saying mail. Some mail was sent. I have not seen it.
There's a very small matter. The petitioner is asking.
Today I am not ready. That is the main problem.
Very well. Then let my learned friend come ready.
In the monthly list.
Mr. Mukherjee, a physical notice could have been given.
That I understand, Lord, but an email has been given, Lord. To that aspect, Lord, I cannot say.
I'm not checking whether you have notice has been served or not.
I also
am not checking who has mentioned when I only consider the urgency, and I assure you I'm going through each and every mentioning slip and I fix a date. Now, if this type of objections come only because notice has not been served, respondent has mentioned email and other things.
I understand this is not for the court, Lord, to consider, Lord. It should have been by Lord, a letter, at least, to show before the court about the proof of Lord notice.
Yes, what is this matter?
Well, I have challenged the mutation granted in favor of the private respondent who happens to be my brother-in-law by the land manager with Urban and Municipal Affairs Department, because the land was, or it is Salt Lake property. The land was
for the private respondent.
Yes.
I say, Lord, they are not the legal.
Name.
Yes.
Now it has been mutated in your name.
Yes, and they are not the legal heir, Lord, so that they cannot be, Lord, mutated. I can Lord, immediately show that
their land was allotted, my lord, in favor of my mother-in-law. She was a reputed administrative officer of this state. Now, after retirement, my lord, land was allotted.
Where is the order?
I am handicapped with the
Lord, page 58. Page 50. But the petitioners, my lord, locus to claim, my lord, mutation, my lord, I have serious, my lord, objection to it.
Where is the, which page is the imputed order?
My lord, the
58.
yes, my lord, I'm 58.
The property was initially recorded in the name of Leena Chakraborty.
Leena Chakraborty. And she is.
Who are you related?
I am the son of Leena Chakraborty. And the petitioner before your lordship is the not the stepdaughter-in-law. Stepdaughter-in-law.
Daughter-in-law.
Yes. She doesn't inherit under section 15. But Nirmal Chakraborty was my lord, father. He married twice. The first wife, Pratima Chakraborty, there was a divorce. And Devashish Chakraborty, my learned friend's lord husband, was not the son of Pratima Chakraborty. My client, Rajorshi, is lord son of Leena Chakraborty. Leena Chakraborty was allocated lord this particular land by the government.
Property is not to the husband. Then who would have inherited?
Because the son will only inherit lord. Rajorshi. Now,
If it would have been your husband's property, then you would have inherited.
During lifetime, mother-in-law has made
16.
15.
15 and the order I think is in 16.
Now here it will not cover the stepson. Stepson is not covered. Devashish Chakraborty is a stepson. And he is the wife of the stepson. She, I mean to say. That is and Lord, the property of 15 is property of a female Hindu dying intestate shall devolve according to the rules set out in section 16.
Firstly, upon the sons and daughters,
including the children of any predeceased son or daughter and the husband. The son.
Husband was dead when you.
Yes, her husband died in 2015. Leena Chakraborty died in 2023. Devashish Chakraborty, he died in 2020.
So, at the point of time when Leena Chakraborty died, the husband was not there.
No. Even Devashish Chakraborty, her husband was not there.
Yes, so husband was not there. So it would be sons and daughters of the female Hindu.
Lordship.
Not of our husband.
And only one Lord, Rajarshi Chakraborty is the only son.
Let me check my fact one second. Today I'm not ready with the.
This is the point of law, not on facts. Facts are admitted. Please see.
আর ওই ডিভোর্সের ডিগ্রিটা দেখা যেটাতে আমরা বলতে চাইছি যে ওর নাম রয়েছে
এন্টাইটেলমেন্ট
তোকে ওই জায়গাটা বলেন পাসপোর্টটা দেখি
Mr. Mukherjee, this is not the decision. The authority has not decided this fact.
This need not be decided.
His claim, anything, whether he was heard.
After the mutation was made, she gave a letter saying that you reconsider. Her husband died in 2020. Now that after it has been mutated.
There is any objection prior to mutation.
And Lord, your Lordship will find Lord, the name of her husband, Devashish Chakraborty, is not in the divorce decree of Nirmal Chakraborty. And
her husband's name, why?
Because Lord, at that point of time, Nirmal Chakraborty was married to Pratima Chakraborty.
Yes.
Nirmal and Pratima had Devashish Chakraborty, his husband, her husband.
Yes. Oh, in the divorce degree, why the son's name will be there?
Lord, because of the custody.
Where?
Not second line, that it is agreed upon by and between the respondent that their only son, Devashish Chakraborty, who is at present 7.5 years.
Presently under the care and custody of the petitioner. Who is
Petitioner
the
means
petitioner?
Nirmal Chakraborty.
Will live with him and the petitioner will maintain and bear all expenses including education will be entitled to see and talk such and such. The petitioner.
And Pratima Chakraborty will be entitled to. My mother is Leena Chakraborty.
So allotment according to you is
Leena Chakraborty.
Leena Chakraborty.
She was Lord the principal secretary of the government of West Bengal at one point of time. In her name, it was Lord allocated. She died in the year 2020.
This is absolutely self-acquired property.
Of whom? Of Leena.
Leena.
If Leena's now you kindly come to 15. How do you come? You are not the son of Leena.
No, but 15 subsection 2 says, notwithstanding anything contained in subsection 1, any property inherited by a female Hindu from her father or mother.
It's not that.
Not that.
First one. Why are you coming to 2?
The property of
Firstly.
It's directly under 1.
Directly under one, sons and
So
daughters.
2 deals with the case. If it is inherited from the father, that will go to that branch. That's the logic.
But
if it has been inherited from the ancestor from the father's side of a married woman, it will go back to the father.
But
that side, not in this side.
This issue was not decided by the competent authority because mother during
deciding that.
Mother during her
I'm
life.
deciding that here and now. If you are not ready, I can give you time because it's a point of law. I can hear and dispose of because as Mr. Mukherjee says that after this mutation was done, you are coming up. So you have to show your legal right to challenge this.
So during the lifetime, my mother-in-law Malat made an application before the competent authority expressing her willingness that I am transferring this property in favor of my son, stepson, which happens to my husband.
That gift did not never happen.
That prayer was made.
That never
The
happened.
gift deed is not executed. Show me
No,
the
that
gift
was
deed.
not executed. Prayer was made. That was not considered. Thereafter, she died. Thereafter, I came to know that this mutation.
So
Then I
can
made
this
application before the
not be
authority.
solved? After all, why?
She is
You
not
are there, Mr.
because
Mukherjee.
we are saying that
After all, he is not an outsider.
Lord, it cannot be done that way because Lord, we have a serious doubt about even the status of the petitioner coming before your Lordship.
Why? You are saying
It is the instruction that she was not the legally wedded wife. That is what the instruction is. I do not have not verified
I
it.
have annexed all the document.
On the
My passport I have
context of
annexed where from it will my name of my
passport
mother-in-law.
doesn't mean anything. Passport doesn't mean anything.
Who is coming now?
The daughter-in-law of Leena.
The stepdaughter-in-law.
Stepdaughter-in-law.
Yes.
What happened to her husband? Why he is not coming?
Husband passed away in
Passed away.
2020. Leena Chakraborty passed away in 2023. Leena Chakraborty passed away later on than the Devashish Chakraborty, the husband of the petitioner.
Oh, Devashish also passed away.
2020, 5 years back.
First page
A second. Don't be so excited, please. I know how much to say, how much not to say.
Yes, what do you say? If you want, I can give you time. You can.
It will not have.
Kindly
The way that your Lordship has expressed that whether there can be a settlement, cannot. Yesterday, my Lord, we had a conference, my Lord, it cannot. In this property, my Lord, I tell you, Lordship, my Lord, your Lordship has seen, my Lord, in respect of this property, the 2/3 has been, my Lord, recorded in the name of my client. 1/3 was subject matter of a will of Leena Chakraborty. That is also probated.
Will, who has got that?
But some other beneficiary has been given. I don't know the name of the person. That's the reason, Lord, my client had applied for, Lord, mutating in respect of 2/3 of the property. So, Lord, there is no scope for him.
Yes,
Even after that.
Tomorrow, I am keeping it.
Instead of tomorrow or next week anything.
Why?
I have some.
I will forget this.
Well, next week any day subject to it also.
10 days.
Then next week any day.
I've got the copy of the probate.
Law only. I will forget this. I think tomorrow I am keeping it at the ashram. 235.
Now, Mr. Dhor, he helped me by suggesting that I should also point out before your lordship the land acquisition manual. There are two provisions, rule 3:13 and 13 capital A. I have been provided also a copy of that instance. 13 suggests that the entirety of the chunk land which has been acquired, the entire quantification of the entire quantum that is required for the purpose of acquisition with bifurcation. And form 13 capital A prescribe different person, land loser, what should be the computation, including market value and solatium, other all components, loss, damages, everything. I have been provided with that copy. I will.
Mr. Mukherjee, again, today I am facing all with same surnames appearing in all the matters. Banerjees, Mukherjees. Any understanding between you?
Always. Normally do not have. But something Mukherjee and Chatterjee not reliable.
Mr. Mukherjee, only one thing. This is an issue with regard to an award.
Award passed by the under the National Highway.
Under the provisions of the National Highway.
National Highway.
How such an award is to be passed?
Award to be passed by the collector taking into consideration.
How?
One of the first, one of the physical verification, then one of the objection is there. Objection to be considered, then section 3 notification.
Procedure. What should be the form of the award? I am on that.
But kindly see section 2013.
Yes.
Rules 2014.
Kindly come to the first schedule.
Yes. Yes, possible. Component of the compensation package is respect of land acquired under market value of the land. Lordship got it. Possible section 30, subsection 2. The following component shall constitute the minimum compensation package to be given to those whose land is acquired and to the tenants referred to in clause C of section 3 of the proportion to be divided by the appropriate government. Market value to be determined provided under section 26. Factor which the market value is to be multiplied in case 1 plus 2 based on the distance project from area as may be notified by the appropriate government. Factor which the market value is to be multiplied in case of urban areas. Value of asset attached to the land or building. Solatium, final award in the rural area. Award in the urban area. Then other component to be included. Then this, if award is passed.
Where is
page
that?
82.
Page
82.
Please, Mr. Mukherjee, kindly come to page 82, whether it satisfies that requirement.
Page 82, 30th April to
82, no, এটা কোনটা দিলেন? এটাই দিলেন নাকি? Yes. Can is thicker than the main writ petition.
No, we have annexed the concessionary agreement. That is why.
Computation of breakup is not there.
That's what I want.
Then?
If that be so, but a matter can be remanded back to the collector.
No, Mr. Mukherjee. His short prayer is that provide the computation.
Yes. We'll supply.
And this is one part. Second part is that why are you not passing an award? Because this is the usual format you are doing in all matters. Then in all matters remanding to the authorities. Why are you doing that?
No.
Why are you not following this? None of the matters you are following this.
No, don't take it otherwise. I have got little experience with the executive bias. Their persons, practically, while passing this order, they should be must aware of the provisions of the statute. How, when this schedule is there in the statute, then must, while considering the passing the award, this component must be there.
Mr. Mukherjee, against this, there is a provision that a person aggrieved can go
before the arbitration.
All right. So with this, what will be the ground in the before the arbitrator?
That should be difficulty.
Then
there must be a ground.
And when you are challenging any order before the Higher authority, you are saying unreasoned order. I have argued so many points. Order does not reflect anything. You are only saying this much, and that is also market value not indicated. After TDS, this is the amount. Please see page 82.
Breakup and computation.
Nothing. So when you give the breakup, they will know what is the market value,
what is the
whether the correct market value, what is the solution, whether all factors have been applied or not. Why are you not giving this? Only for this, Mr. Mukherjee, this court is
This should be. But may I request your lordship? Kindly pass directions so that this all the officers who are working with the national higher authorities passing an award acquisition proceedings, so that this should be the guidelines for the authorities concerned. They must comply section 32 and first schedule while computing the compensation, so that nobody should approach the court first. They can approach to the arbitrator.
Why all times the directions from the court is necessary? What for the officers are there, Mr. Mukherjee?
Manad, I am defending a blind man with great respect.
Mr. Mukherjee, you are there. You have to tell them what to do because they are not following this. And if only on this ground and the order, maybe the computation and other things is all right. What you are saying, that must be a basis. But only on the solitary ground, this will be set aside. Again, another round of this adjudication.
It should be the guidelines for future actions for all over West Bengal for the land acquisition officer under the National High Authorities Act.
You frame a suggested guideline, I will approve that. Please give a suggested guideline. I will approve.
They must follow the act.
Because since you are here, please give a suggested guideline. I will follow that.
I
will follow that.
No, when the judicial order is passed.
With the leave of Mr. Mukherjee, my lord, I have been asking, my lord, that if we can catch hold of the Form 13 and Form 13A, this is Form 13 deals with the entire area, how much area and for which project it was acquired, and the total valuation is written in Form 13. And under Form 13A, it dena to mobile ta dena. Under Form 13A heading, X has got 5 kathas of land, then share, then market value, then construction. For construction, what would be the charges? Then solatium, then additional compensation. Altogether, X gets such and such amount. I have got this. Malad, kindly have a look, Malad. Kindly have a look.
Why this is not being followed?
Malad, must be. There must be before finalization of award. Kindly have a look. Malad, that's why I'm asking Mr. Mukherjee Malad to get the instruction from the
mobile এই সব গন্ডগোল কোথায়
ঘুরে গেছে নাকি
এটা ম্যানুয়ালি আছে তো
হ্যাঁ ম্যানুয়ালের পেছনে আছে
Or your mobile is much more costly.
no
Must
মানে I was দাঁড়া তুই উত্তরটা রাখ আমি আমার এটা খোল
এই তো না
Yes.
Malad will find, Malad kindly come to Form 13, first one.
Yes.
On top, Malad will find C paragraph number such and such, then land acquisition case number such and such, then proceedings under section 11. Malad has got it?
Yes, yes.
Act 1 of 1894. Like this, if it is Act 2, there would be written Act 2 of 1948.
This is the total amount.
Yes. Name of the project on the left-hand side, then Rajarhat New Township, then Mouja, then Malad, at the end, Malad will find the total value of the land, such and such.
The apportionment is in 13A.
Yes, Form 13A. Now, Malad, kindly come to Form 13A. Awardee serial number wise, Malad will find that how much share, what would be the land value, what is the solatium value, what is the damages. If damages is 0, then my lord will find damage.
I'm saying that those components, it might be 0, it might be something. You have to indicate that against each head so that he knows, he can challenge that. So that he can challenge. You may say damage is 0. He can say, no, I have suffered this much of damage. You have not considered that. The scope of challenge may also be limited there.
Form 13
Time so that I can bring that whatever the basis of calculation of this.
Because Mr. Mukherjee, in most of the matters, I've found that this is the only form which is being annexed. Now, maybe the petitioners are not providing the entire thing. It may be also that you have.
You can apply for certified copy. You can apply for certified copy.
Mukherjee, why you will apply for the certified copy? It's your duty. Why certified copy? You have to pass an award. You have to give them. They must know how you are calculating. Why you are hiding that? Instructions, how these calculations are made, and ask them in each matters the person, this apportionment must be given.
Kindly see, just like don't take it otherwise. LA case number 3 NH 1161 22 23. Vested area, actual area, classification of the land, rate per acre, land value, factor 1, factor by rate per acre, market value of the land.
Where you are reading from?
The petition of this.
This is the
No,
report.
No, this is the
It's an instruction.
This is the instruction.
আমাদের
National Highway 1161.
Yes, here you have given the entire thing.
But substance under section 3, capital of national area.
এটা দিচ্ছে 3NH
Why are you not providing this to them?
I will supply them.
LA case number is not matching.
No.
This is just an instance Mr. Mukherjee wants to take.
Yes.
So like
So
this,
in
if
this
we
matter,
got,
you provide him that he only
that's
wants
point
that.
of the matter.
Please provide him. He only wants that breakup.
Rural.
This is, Mr. Mukherjee,
একটা
this is
second,
also
sir.
not an award because this is an estimate.
This can't be. That form has to be there, my lord.
This is an estimate. You have estimated. This is not the award.
ওই form
This is the
দরকার তো।
caption. It's estimate.
Not the
You have estimated that amount. You want that amount from the requiring body.
Yeah.
That's a different thing. This is not the award.
স্যার ওই ফর্মটা
So that I can computation and the form 13.
When?
2 weeks time may be given. 2 weeks time may be given.
My lord, in the meanwhile, my lord would be kind enough to
Yes,
dispose
Lord.
the CAN application
Can
alone.
I'm allowing. I see that you are not prejudiced.
handing over the paper. And the officer concerned who is dealing with the, they are in their office. That's the difficulty. Until unless judicial order is whenever this is not proper on the part of the authority concerned, they shall have to follow this schedule or the that will be the guiding factor to all the land negotiations under the national.
Then request the learned advocate general to appear in this matter. I want to hear from him that what will be his submission also with that, whether he can take care of this issue or not. When you senior advocates are there, senior.
If somebody comes, we can guide him. And the man who is coming will just with the records.
Make a request to the learned advocate general to appear in this matter, then.
Sorry.
Thank you. Obliged, ma'am.
Yes. For the next matter.
Item P04.
Yes.
But I appear for the private testimonies. May I be permitted to join virtually?
Yes, yes.
But after this writ petition is filed, my lord, we have received this communication, if your lordship and it.
What communication you have received?
My lord, from the assistant engineer, my lord, we have received that from the end of the assistant engineer, my lord, inspection has been carried out and some construction.
Parawai statement of facts.
My lord, I don't know, my lord, how, my lord.
How can you get this Parawai statement
Same,
of facts?
same
I
things
don't
I
know,
have
sent-
received, my lord.
Sent to me. I don't know.
Lord, I don't know, my lord.
And my lord, what you kindly see is
Who has sent you this?
this is from
My lord.
assistant engineer PW Road. My lord, I understand, my lord, what happened.
I have
received
this
this, my lord.
same documents, my lord, I have received.
And my lord, if your lordship kindly sees, my lord, it is, my lord, there in the fourth page, my lord, that a request has been made to the concerned demarcation. And that has not been, my lord.
Yes, how soon the demarcation will be made?
No, my lord, page number 10. My
Yes.
lord, page number 10. My kindly have a look, this page number 10.
This do not have any page number.
No, my lord, I have. My lord, kindly, my lord, page number 10.
Page number 10, yes.
Same. My lord, kindly see the report sent by this BLRO to this assistant engineer, my lord.
Yes. Noinjuli. Yes, now what is your instruction? What you will do?
And there's my lord, kindly, my lord, send back and my lord, we take appropriate steps as per my lord, Highways Act, my lord.
My lord, may I be heard, my lord? So far as the allegations against the private respondents are concerned, my lord, they are standing there, my lord. They have not made any construction on PWD land. The construction made by them.
There is any construction, no action will be
My
taken
lord,
against you.
whatever they have made in private land, suit is pending between the petitioner and the private respondents. There is a civil suit pending. We are fighting out before the civil court.
My lord, they carried out a
But-
suit, my lord.
But that is with respect to private land. And we have the valid sanction plan as well. And we have the statutory
They have
license.
found encroachment, are directing them to conclude the proceedings.
My lord, upon giving opportunity of hearing to concern,
yes.
because I do not know whether I am at all involved in all this.
Yes, yes.
To concerned parties, my lord.
The petitioner.
Well, it's,
10723. Jail number 6. Within Moja Uttor Hazrapota.
May I get a copy, my lord?
Yes, give him a copy. Yes, call the next matter.
Lordship,
My lord, the same order maybe.
same. My lord, only one thing, my lord, I could not.
Same order. Yes, next.
My lord, I could not hear the dictation. My lord, my submissions have been.
Yes, your submission recorded. Yes, call the next.
Grateful.
Yes. 418.
State.
This matter was mentioned.
Item number 122. This is the matter, my lord, where there was an allegation, my lord, against the writ petitioner that he was. I am appealing for the petition, my lord, led by Mr. Ashok Banerjee, my lord. He's coming, he's on his way. He was excavating
May I
illegally
may I just
mining.
place my case? Lordship kindly takes up my writ petition. Or rather, Lordship takes up their opposition first.
They won't be using affidavit in reply.
Yes. I have.
You have used the affidavit in reply?
Yes.
Have you given a copy to him?
Yes, this was served.
When?
No, I do not have.
Please show it to him that you have served him. Yes, you have received, Mr. Dhar.
দেখি কোথা থেকে বার পেলে? ও স্যারের কাছে ছিল। It was remained with my learned junior.
Yes. Yes, what is this?
Lordship kindly
Where
takes
is
up
the reply?
Page 65. I filed. I have page 65 of their opposition.
Page 65 of
Page
their
65 of their
opposition.
affidavit in opposition.
Where is the affidavit in opposition?
That they have filed right now. Yes, sir.
Uh-huh.
Not probably here. Not probably here.
The affidavit
It
in
didn't.
opposition. And your reply? Where is your reply?
But I filed.
Yes. Yes, opposition, which page?
Opposition page 65.
65, yes.
Now, this is the order of the Honorable High Court, which was relied on by the District Magistrate Bakura while passing the order impugned.
Yeah, please give me the facts first.
There was a short-term mining lease for a period of 5 years,
Yes.
which was, I'll just place the dates. The mining lease was.
Give me the facts thereafter.
Yes, I'll place that. But 22nd June 2018, the short-term mining lease was executed for a period of 5 years. Now, what I was carrying on, then ultimately there was a show cause on 14 December 2020, making certain allegations against me. But immediately I made replies. Those were not considered. The first hearing was given on 28 February 2023, but no order was passed. That is at page 104 of the writ petition. That hearing was given to me. No order was passed. Thereafter, my lord, I filed the writ petition before this honorable court, and this honorable court directed my lord, the District Magistrate Bakura to hear me pass reasoned order. Now, my lord, after that, my lord, reasoned order was passed. I challenged that order before this honorable court. This honorable court entertained my writ petition, set aside the order, set the matter back to remand. So, my lord, this went on ultimately, my lord. The honorable coordinate bench, my lord, 4th August, my lord, 2025, again set the matter on remand, and my lord, on my lord, 21st August 2025, the District Magistrate Bakura passed the impugned order, which is subject matter of challenge before Lordship's court.
Where is that? Page?
No, my lord, 248 of the writ petition.
248. That is under challenge now.
That is under challenge now.
Yes. Yes. What is the infirmity in this order?
Lordship will kindly consider. This order, my lord, was on the basis of a particular inspection report. And it was alleged that an inspection was made at the property concerned at the leased area, and certain infirmities were found by the inspection team. Initially, that copy of the report was not given to me. Then, my lord, I filed the writ petition. Then the honorable coordinate bench rejected them.
Thereafter, you got this.
Thereafter, I got
When
that.
this order was passed, before that you got
Yes,
the
before
copy
that
of-
I got that. Now, my lord, this order was passed. I had taken a point that the allegations, there were certain allegations against me, that there were overloaded trucks. Then there was, my lord, I had used certain things which I was not supposed to. But against that, I categorically replied that I did not use these things, and they had to show me that, but they had to satisfy themselves only that if there were overloaded trucks, then, my lord, the number plate of the truck, the registration number, there was nothing. There has to be a seizure, there was nothing. This, Lordship will kindly find in the impugned order, he has recorded. Lordship kindly takes up page 251. This is the inner page 6 of the impugned order.
Yes.
At the last paragraph. It is seen from the available office and file records that there was no photograph or seizure list with the report of the joint inspection team as supportive documentary evidence. There was nothing. There was nothing. This is one of the reasons why my prayer was rejected. So, my lord, without this, my lord, I say that the inspection carried out was not at all in accordance with law, my lord, since he has there was no supporting, my lord, documentary evidence. Now, if your lordship will kindly, now, my lord, in the meantime, while these hearings were given, I had made representations, I had made replies. In the meantime, my lord, my lease had expired. Lease was for a period of 5 years. So, in 2023, the lease had expired. Now, my lord, this is my state. While considering my case, lordship kindly takes up another point at inner page 15.
Inner page?
Inner page 15, page 260 of the writ petition.
Page 260. Where is the inner page number mentioned?
At the top.
Oh, that's the running. Oh, yes.
Inner page.
Beneath.
Yes.
Inner page 16.
15.
Yes,
At the
15,
bottom.
yes.
Reliance is made on the observation of the Honorable High Court of Calcutta in WP number so and so in the matter of Hemanta Kumar Ghosh. Once the lease stands expired, the lessee cannot claim any right under such lease. To renew or to execute a fresh lease is the total discretion of the lessor or lessor stand expired. Such an obligation or discretion cannot be enforced to read code in as much as for specific performance of contract read code. Now, this order they have annexed in their affidavit in opposition, where I had tried to start my hearing from. Now, Lordship kindly takes up their affidavit in opposition. Page 65 of the affidavit in opposition. But Hemanta Kumar Ghosh, which was relied on by the DM Bakura, see what order was passed by the
65.
Page 65 of the affidavit in opposition. They have annexed that order.
Yes.
But I'm placing from the 1 to the 3rd paragraph.
Yes.
The petitioner states that by virtue of a lease agreement dated November 18, 2016, a mining lease was granted to the petitioner in respect of the piece of land for excavation of sand block. The lease tenure was for 5 years. The lease expired on November 17, 2021. Learned Counsel appearing for the petitioner submits that due to intervention of the COVID period, the petitioner could not carry out its excavation job and the lease had expired. The petitioner submitted representation dated 1st November 2022, which was received by the appropriate state authority on November 27, 2022. And next at P2 at page 62 of the writ petition requesting for renewal or extension of the lease. The said representation has not yet been considered. Mr. Swansol and Mr. Line Additional Government Pleader appearing for the respondent submits that the record shows admittedly the representation was submitted nearly about 1 year after expiry of the period of lease period. Relief relating to the specific performance of contract for renewal of lease after expiry of lease cannot be granted by a writ court. After considering the rival conditions of the parties and upon perusal of the materials on record, it appears to this court that the lease was executed on November 18, 2016 for a period of 5 years, and the currency of the lease stood expire on November 17, 2021. Admittedly, the application was filed much after. This is the key thing. Once the lease had expired, the lessee cannot claim any right under such lease. Now, here, what this honorable court has recorded that the representation was made after 1 year. But in my case, Lordship will kindly take up the dates, my lord, immediately with after the show cause, I had made my replies, and within the period of my lease, I made representation. I was given the fast hearing, that too within the period of my lease, but no order was passed. So, my lord, admittedly, this order which has been relied on by the DM Bakura is, my lord, not applicable in my case. Honorable Coordinate Bench held that the representation was made 1 year later on, 1 year after the lease has expired. Like this, they have given in their affidavit in opposition. So that is why I state that I will start from the opposition itself. My lease was still, my lord, 22nd June 2023.
What is your right to get extension after the expiry of the lease period?
Well, I made my representation within the time. My reply was also within time.
So
In
your
fact,
right to get
yes, that I'm coming on. Now, my lord, Lordship,
if you make a application for extension, where is your right to get a renewal of that?
no, I had made that, but as show cause was given to me. But I had replied to that show cause. Then Lordship will kindly consider that a hearing was also given to me. The Lordship kindly takes up page 104 of the writ petition. 104 of the writ petition.
What is the relief which you are claiming in this?
But I could not want to carry out my work. My lease was not terminated. I was not even suspended. My period was made for show cause. For the entire period, I could not carry out my work.
Why? Why you could not carry?
Because of this show cause.
You are stopped from
Yes.
carrying out.
Yes. I was stopped from carrying out the entire period, the remaining period.
I'll just, my lord, place certain annexures from their affidavit. Thanks to my friends, he has helped me by using this affidavit. However, to appear what is actually happened. চশমাটা কই রে?
Banerjee.
Page 38, their affidavit.
Their affidavit, yes. Yes.
It's the elaborate order passed by Justice Parthasarathi Sen, and I need not read the entire order. Can you take trouble to come first, page 40. Page 40. The way they are, last paragraph. Have you got it, my lord? It is submitted by Mr. Dey that Rule 51(2) of the said Rule 2016 clearly mandate that in the event any person is aggrieved by an order made by this district authority, the remedy lies to him to prepare an appeal before the Jurisdictional Division Commissioner. It is thus submitted, Mr. Dey, that in view of the ability of the alternate remedy, this court must be very slow in exercising the judicial court. On careful consideration of the entire material as placed before this court, and after hearing the learned advocate by the contradicting parties, it appears to this court that admittedly while disposing such as this court while setting aside the order under challenge, they are granted liberty to the representative to file his written objections. That is also straightway against the order. From 5 authority. As rightly pointed out Mr. Sachin Sach, this court by the same order directed the respondent number 5 authority to pass the reason order on the representation of the writ petitioner after giving adherence to the written objection as well, sir. Undisputedly in compliance of the such written objection was filed on careful considerations of the order under challenge dated such and such. It appears to this court that the respondent number 5 authority while passing the said reason order though considered all the pros and cons of the report on the basis of the joint rate program dated such as well as the other factual aspect. However, the Respondent 5 authority made no whisper at all as to why such merit, no merit in the written objection has submitted by the petitioner. In fact, this court has noticed that while passing the order under challenge, such, the Respondent authority has not dealt with such instance. Then, my lord, paragraph, next paragraph, this court thus considered Respondent 5 authority while passing the order under challenge, such has acted contrary to the direction sunset passed by Sanjay. Admittedly, The writ petition has an alternative remedy in preparing the appeal before the division commissioner. However, since substantial material have been placed on behalf of the writ petitioner, the Section 5 authority had acted in complete deviations of the defiance of the order of this court. This court cannot sit idle over the matter while sitting in a writ jurisdiction, keeping in mind that the power of the writ court is highly prerogative in nature and same cannot be restricted even by the statute. There I also pointed out that judgment of Justice Madden. Consequently, here we allowed. Then, my lord, kindly come to next page. 48. 48. Page 48.
Yes.
Have you got it, my lord?
Yes.
A joint raid program conducted on such and such date by the such and such practitioner over the plot of such limited. A report was sent to this. No notice, nothing. And no serious. I'm coming. The lessee is using the machinery. These are all question of fact to be gone into. And in my presence, that should be done. No notice, nothing. I do not know anything. The lessee is using the machinery like suction pump, filter, extract essence. I denied that. I'll come to that. The lessee has also made a wooden bridge connected such and such. No demarcation pillar found under such. There is no so many overloaded truck found. There is no staff of the lessee found at his office to be interrogated. Did you serve any notice? They are paid men. So I'll have to pay for that. Why should I? Why did not? Then, so notice is issued as petitioners. Then, a reply to that limited complete, denying the fact of illegal mining, although in his reply to such, he admitted the fact of illegal mining and requested they allowed him for mining of the due consideration. That letter I also saw, Lord, says, my lord. My lord, difficulty is, my lord, it is very difficult to find out what is the last part. And I agreed. I said, very well, that is my mistake. Whatever you want, I'll pay, no problem. So there is no malafide. Then last. All the point I dealt with in this, in the instant writ petition, the Honorable High Court, Calcutta has been pleased to set aside the order. Then other parties also giving. Then kindly come to page 50. In point number 7 of the written objection, the petitioner has challenged the report in terms of all paragraphs of the report. The report is not supported by any kind of evidence like photographs or any Caesar list or any other materials. As such, the purported report is based on non-evidence, cannot be relied upon by the district magistrate, Bankura or Pasagi. It is seen from the available office and file records that there was no photograph of Caesar. Kali marked it, my lord. They have admitted Caesar list with the report of the joint inspection team and supporting document evidence. Nothing is there. On perusal of the written objection as submitted by the petitioner against the joint report, it is found that the petitioner has made his objection containing 1 to 5 of the report from point to answer. The point number 1 to 6 of the written objection are factual details as introductory part of the point number 13 of the written objection are the closing argument with word to allow mining operations. I couldn't follow the heading. In point number 7, the written objection, the petitioner has challenged the report in terms of the paragraph of the report is not supported by any kind of evidence. Photographs, it is seen from the available office records. Point number 8 is also with regard to paragraph 1 of the said report, it is stated that the petitioner lessee never used any suction pump, filter, net machines, or for extraction in any such as article overseas from the office of the petitioner lessee or the mining site without any such seizures by the alleged inspection team. Such allegation is baseless and, my lord, preposterous. Accordingly, the sufficient of London advocate at the time of the hearing was made. Both the attendant and authorized in absence of photograph as questioned by the petitioner in his objection. I expected very well. What is there? I am keeping record.
Yes.
Objection. The authority relied upon the report of the officers authenticated with a joint signature. Who was present there? Me? No. Two authority was there. They signed 36%. This is honor. This is absolutely against the contrary of the law, established law. That well, a person who livelihood will at stake, a person according to them has committed a mischief and mistake, he must be given opportunity hearing, notice to be served on him, and these are all factual allegations. I strongly denied. I say, very well, prove it. Nothing. No. Since report is there, signed by both the authority, I am not that person. So that is sacrosanct. This is honored, my lord, I should say. The point number objection against the photograph also the said joint inspection report is stated by the petitioner. The wooden bridge was made without any hindrance to the natural flow of water, but only for the purpose of carrying out the sand mining activities from the other side of the river, as a ghat was at the block. So, my lord, their allegation is due to construction wooden bridge obstruction. I strongly deny. They could have asked me, please come here. Here is obstruction. So he will be punished. No, nothing. Then, my lord, kindly come to page 54. In point number 610, have you also got it, my lord? 10. The written objection against the paragraph 3 of the said joint inspection report regarding demarcation pillar. It is stated by the petitioner that the pillar were always there. The petitioner, while carrying on the sand mining activities, took special care to see that the safeguards were always there. If the allegation is as made by the inspection team was true, then they ought to have been approached the office of the petitioner on the date of alleged inspection. Repeatedly, I do that inspection. What you have done totally wrong. Then, page 55. In this regard, second paragraph. In this regard, it is seen from the available office and file records, there was no seizure of vehicles at the mining site by the joint inspection team. They themselves admitted. Team, the seizure of overloaded vehicle is only possible after weighing the vehicles as per section 39 of the Act, and when the overloaded vehicles are in motion and not standing. As per point number 5, the report there is none to interrogate. How you can expect? Unless a notice is served, how we can expect when they will go, when they will visit, and they are not actually salaried persons. They have got their own time. Is the allegation? I got the information. I told them, get out. No, there's no allegations. Then I could have understood. Yes, sometimes may happen. But here, to cover up their own fault and defect, they did all these things. And they admitted practically, yes, this is wrong. In point number 2, written objection against paragraph 5, the said joint inspection report is stated by the petitioner. The office of the petitioner is always attended by staff. Moreover, the petitioner uses expensive machinery for the said mining purposes. Hence, to guard the expensive machinery, there are static guards posted on the mining site throughout the seasons. It is specifically stated that the alleged inspection raid never took place on the site of the petitioner mining operation. This is very serious allegation, my lord. My God is there, my valuable machinery is there. He could have ignored that. Please come and sign. And come here. We are making inspection. Sign it. They could have. So that was done in elsewhere. Now that is a very big.
Valuable machineries for what purpose?
Extraction, yes.
Extraction.
I'll have to. And these are hard machinery. I'll have to pay back. I'll have to pay return.
Yes.
On perusal of joint inspection report under scrutiny, it is found that the team has mentioned there was no staff of the lessee found at this office to be interrogated, which has been denied by the petitioner, stating out logic behind it has been there was always men to protect the expensive machineries. To cover their own mystery, but if I permit to say, they have said, now this is the nothing but the. Then, kindly come to page 65.
65.
Probably my friend has already shown you, losses, my lord, the judgment of Justice Aniruddha Rai. And this is a completely different context. My lord, remember the judgment of Justice Arijit Prasad. Before applying the judgment, you must be very careful. There may be some sort of security. That doesn't mean that will take it as a precedent. But there is a completely different context. And DCMA says,
slightest difference in facts.
My lord.
Slightest difference in facts.
Yeah, I'm grateful, my lord. Remember that. Of course, my lord, remember. So even that make a gross changes. Ordaining observations, my lord. So, my lord, this is the position. Now, what they did, my lord, yes, I admit it. I'm not a crooked. Kindly come to page 24.
24 of?
Affidavit. I'm denying their affidavit. All.
Yes.
শোকজ প্রত্যাহার করে বালিকাদান চালু করার উপর আবেদন মহাশয় আপনার কাছে আমাদের বিনীত নিবেদন যে আমি প্রোডাক্ট লিমিটেড এরিয়া পাত্র স্যারকে মেমো নমস্কার আছে তার শোকজ অবৈধ বলে উত্তরের জন্য মহাশয় আমার বিনীতভাবে ক্ষমাপ্রার্থী আমরা ভুলবশত আমাদের ডিমার্কেশন এরিয়ার বাইরে চলে গিয়েছিলাম আমরা তার জন্য আন্তরিকভাবে ক্ষমা চাইছি এবং ভবিষ্যতে আর এই ধরনের ভুল হবে না তার অঙ্গীকার করছি তাই আপনার কাছে অনুরোধ করছি আপনাদের সমস্ত ভুল ইটস ভেরি কমন মিস্টেক দেয়ার মাই লর্ড বিকজ অ্যাজ সাচ দেয়ার ইজ নো স্টেট বাউন্ডারি. So naturally, in doing so, sometimes we cross our area.
How many times you crossed area?
This is the first time. Very
No,
rare.
page 25.
Yes.
Page 25 again.
No, same so cause.
No.
Yes. Only one so cause. They have annexed only one so cause. Against that, all this. Kindly read my lord. Same so cause.
Yes.
Same so cause. That is the only occasions. And the most interesting, same so cause. Most interesting thing is, my lord, in one case, eventually I appeared in that case, my lord, Radharaman. There, my lord, what a report is, there, my lord, after taking penalty, they are out. How they can make a discrimination in this way?
No, I could not follow. After taking?
Same socos was issued to Radharaman. They also excavate the sands. Same type of socos that was issued. Page কত ছিল জানো?
May I get a copy?
পাবে ব্যস্ত হও না. These are all matter of record. Kindly come to page 2.
Matter?
Page 220. 228 of the petition. Na?
This is only a note.
দেবো ব্যস্ত. My junior, na?
Advocate, but it's not junior too.
I think so, but whether he will admit or not, I do not know. The other day, very interesting. Other day, I was arguing one case before one honorable judge. I will not take the name of judge. The other side, who was appearing, I had a privilege to appear against his father in so many cases. And this lawyer, the member of the Parliamentary Class, he assisted me in so many cases. He must know the ethics of the court, and I'm grateful. I'm so glad to hear that Mr. Such and such, he told me I must learn. After 52 and 50 years, I have not learned nothing. And he's for not only 20 years or 25 years. It's misfortune on my mind. I learn from you, my dear. I learn from you. So I'm very much scared and কখন কে কোথায় Calcutta page 228 of the writ petition.
Yes.
এগুলো আমার বিটটা দিন of Margot. Shokos. To whom Radharaman at top the same
date, same Shokos.
Same date, same Shokos. And both the guards side by side. For our Shokos, page 96. Kindly compare.
96, yes.
And this is 228 Radharaman. Radharaman got a blessing of the High Court. Because no, the way it has been done, this is very unfortunate. The way you are proceeding is very unfortunate. Everybody know the.
Where is the decision in Radharaman?
Radharaman. 2 to 9. So the demand notice for submission of penalty for illegal.
Yes.
The penalty. And they are happy.
Yes.
Calcutta page 230, 230. They are working. So what's wrong? Even if I committed wrong, you cannot make a discrimination in this way. Side by side. And other judgment. Here it is. And several times I approached the Honorable High Court. One after the other, Justice Ghosh was compelled. I am fed up. What is going on over here? Mandatory order, page 273. And there I cited the judgment of Justice Madam. Power of the High Court is not so small. It can be curtail or snatch in this way. We are sorry to say days have come. They say, whoo, High Court ki bother. Paragraph 23, specific direction. The Assistant Secretary, Department of Industry, Commerce and Enterprises, being the second respondent hearing, is directed to allow the representation submitted by the petitioner and grant extension of the lease for a period during which the petitioner was unable to continue mining operation. Inter should be completed in 6 weeks. It's a mandatory order. And that is the effect. That effect has been already given. No appeal, nothing. Effect has been given. It is a judgment. It's not an order. And this is the third time, my lord, before Justice Ghosh. Another very interesting thing. I'll come. On to page 231. They say, no, your lease period has been expired, I'll not issue the challan. In each case, they are making the discrimination. For what for, I do not know. Maybe some other reasons. Page 231. And calmly come to page 232. See.
Yes.
Challan that has been issued after expiry of the lease. Specific. They didn't answer it. They didn't answer. They avoided all these things. For obvious reasons. Kindly marked it, my lord, 22. That has not been denied. How they will be able to deny it? Because they did it. Kindly see. 2, 3, 4, 5. Fifth column. Date of expiry. 26 March 2023. Lokesh Kakkar. It's very relevant.
Yes.
ওটাতে আমরা কি বলেছিলাম জানো?
ওকে ইস্যু করলো চালান। এটা কবে? 38 চলে যাচ্ছে। 35
বাবা তো 235. Kindly see.
This Lokesh Kakkar, you are saying this challan was issued after the expiry of the lease period?
Yes. Kindly go to 235 page.
This is 231.
235, kindly come to page 235.
Challan as on 13th of October 2022. So this was passed in 2022 when the lease period is to expire in 2023. It's not after, it's prior to that.
235. I know, my lord, it was 235, page 235. Kindly continue page 35.
235. Yes, 11, 2023.
Kindly see.
Date, issue date.
Issue date at top. 5th 11 2023.
Lokesh Kakkar.
Lokesh Kakkar
At the bottom.
at the bottom.
Where is your allegation against this? Case made out.
Paragraph 36, my lord.
36. What is the reply?
What they did not reply. What they will reply? Because they met on record.
একজন আছে নাস্টেড
আরেকটা আছে বার কর
নাস্টেড দেখাচ্ছি এটা তো স্যাটিসফাইড তো
দাঁড়া just say পড়তে
হ্যাঁ
দে
তার সাথে দেখুন
Have you got it, my lord? Even after extra release, they have given challan. And they say no challan to be issued, so far you are concerned. আরেকটা কথা বার কর Another instance was there. I'm trying to find out. Yes. 233. Calicut page 233.
Yes.
7.
Horrible question, right? 7.
Yes.
Nag Trading Company.
May 2023.
Well, expire, Kali marked it, my lord. Serial number 7. Have you got it, my lord?
Yes.
Nag Trading Company, 9/5/2023. Expire. Chalanta.
239, 240, দুটো পেজ আছে।
Have you got it, my lord? 239. It's a maze practically. Those who will oblige, they'll get it.
239, 240, 241, তিনটে চালান।
239, 240, we have been able to collect 3 challans. 239, 240, 241. Can you see?
Yes.
238, 238, 239,
Hmm.
এই ভাবিকে তলার পেজটা দেখেন এই যেখানে
দেখেছি জানি তো they proceeded. And we have stated on oath, my lord very rightly put this question, Mr. Manager, why we have stated. Page, paragraph 36 specifically have, and no reply. And now Supreme Court is very candid, my lord, 93 Supreme Court. If you do not controvert by filing an affidavit, with the court an opportunity, that means admitted. It's a fundamental principle, my lord, that you are not denying. So in one case, you are doing all these things. In other case, you'll make it discriminations. How is it? But their answer, I know why, what playing in the law's mind. I'm trying to know. Because we have stated here. Now I could have understood. Of course, that plea has not been taken. But to be frank, no, there is no question of negative equity. No, this principle doesn't lie here. This will not lie here. Because after the court's order, you know what is the position. In spite of that, you know the lease is expired. In spite of that, when you extended, then naturally you are answerable to the court. What you have done. Mr. Banerjee also get the same privilege. What Mr. Subhakosh, that's also observed. I am entitled to get that. Why you are making the discriminations? I will not oblige you. I never oblige. Otherwise, kindly see the bona fide of my client. He admitted in writing. He said, kindly excuse me, and he agreed to pay penalty. So he was not obliged. Other persons, they have been obliged. If it goes in this way, there will be scandal. There will be other things. But those who are doing business honestly, they are near in trouble. And very rightly, my dad put this question: how many times you have committed that mistake or mischief? Just once. Abar ki holo. Hearing. This is the situation, my lord. Where shall I go? What wrong I have committed, my lord? Yes, I have committed wrong. I cannot deny that. When I agree I have committed wrong, when I plead the guilty, they cannot penalize in this way. Not that I can do discreet. In each case, my lord, no notice before inspection, no photograph, no documentary evidence to prove that, well, it is obligation on their part to prove that, well, I made an inspection, I got it. Nothing.
Anything more?
মক্কেলের বলা very rightly Bhaila put this question. They have not dealt with any paragraph. For obvious reasons. They cannot, I know.
Yes.
May I just?
Will kindly take up my affidavit in opposition once. I'll place only paragraph number 4 and I'll show all relevant annexes.
Yes.
Kindly come to para 4A. We'll find the area 11.88 acres and then 5 years. It was executed on 22nd May, then subsequently registered on 23rd May. Kindly straight away come to the show cause, which is at page 20 of this. Whereas on the basis of inquiry reports received, it appears that illegal sand mining activities are being carried out by you in respect to your leased out sand block at Siliaghata area under Patroshire PS beyond the provision of lease, and whereas such illegal activities of the lease are in contravention with the existing rules, guidelines, norms and procedures of sand mining, and then such illegal activities of the lease are also causing the environmental damage in that area. Now, Malad, kindly turn to the next page, 21. That was the inquiry report. And Malad, in that inquiry, the concerned SD Lelaro, Bishnupur Bakura, went to the inspection site and then found this. It is found that the lessee is using machinery like suction pump, filter net machine and boat for extraction of sand from riverbed. Depth of the extraction materials at the riverbed shall be kept restricted to 3 meters from the existing bed level in the quarry, mining area or average ruling water level in the river or drainage channel or irrigation canal, whichever is less as per the terms of the lease deed. The lessee SG Project Limited have extracted sand more than 3 meter depth from the existing bed level of the river, which is also harmful to the natural course of river. Then 2, the lessee SG Project Limited has also made a wooden bridge continued with long sand bridge come road inside the riverbed, obstructing free flow of river water. As per Sustainable Sand Mining Management Guidelines 2016 issued by Ministry of Environment, Forest, such and such, streams should be diverted for the purpose of sand mining. No natural course and or water resource should be obstructed due to mining operations. But the lessee has made a temporary bridge on the river obstructing the stream of the river, which is contrary to the above mentioned guidelines. For this, there is every chance of change of natural river course and environmental imbalance may also be occurred. Then 3, no demarcation pillars found around the periphery of the leasehold area. And there are so many overloaded trucks found in the vicinity. And then there is no staff of the lease found at his office to be interrogated. Now, Malad, kindly turn to the next page is the typed copy of that inquiry report. Now, Malad, kindly come to page 23, 28 December 2020. The SG projects is denying that they have not flouted anything. absolute denial. Now I'll kindly come to next letter, that is on 28th September 2021. মহাশয় আমরা বিনীতভাবে ক্ষমাপ্রার্থী, আমরা ভুলবশত আমাদের ডিমার্কেশন এরিয়া বাইরে চলে গিয়েছিলাম, আমরা তাহার জন্য আন্তরিকভাবে ক্ষমা চাইছি এবং ভবিষ্যতে আর এই ধরনের ভুল হবে না তাহার অঙ্গীকার করছি, তাই আপনার কাছে অনুরোধ করছি। নাও my lord kindly come to 26th October 2021 at page 25. Same thing. Then my lord kindly turn to the next page, page 26. Kindly come to page 27. This representation, withdrawal of show cause bearing number such and such, they are writing before the district magistrate. Kindly read para 6, that the SG Projects Limited filed its reply on 26th October 2021. Thereby it was admitted that by mistake the sand mining activities was done beyond the demarcation area as per the lease. It was further prayed before the authority that the show cause may be withdrawn and the lessee may be allowed to carry on with the mining activities as per the lease. Then my lord kindly turn to page 29. Again, reminder, again, same thing, para 6, they have accepted that they have done a mistake. Then very interesting at page 32. Whenever somebody gets the auction bid, they have to deposit or put in a money which is bank guarantee till the existence of the lease period. Now I'll kindly read this page 32. Release of bank guarantee number such and such of 2018. With reference to the subject noted above, this is to inform that the bank guarantee bearing number such and such amounting to rupees such and such respectively are hereby released from this end, because they made a prayer and on that basis district magistrate is informing the branch manager that kindly release it, because their lease period got over and they have asked for it. I'll be placing, kindly come to the para 11, affidavit in opposition. I say that thereafter petitioner filed Yes. Then in the matter of SG Projects Private Limited versus State of West Bengal, and praying for issuance of order for extension of lease period for 2 years, 5 months. Malata's got it.
Which page?
At page 11 of my affidavit in opposition, para G, last.
G.
Yes.
Last.
Malat G. It starts from small g.
Yes.
In compliance with the order dated 4th August 2025 of the Honorable High Court, Calcutta, in connection with WPA number in the matter of SG Projects Private Limited versus the State of West Bengal and others, and praying for issuance of order for extension of lease period for 2 years and 5 months. The grounds on which the instant writ petition has been filed are not tenable on the face of facts and such I am not placing. Then firstly, the representation prayer of the petitioner can't be entertained, as there is no provision either for renewal or extension of mining lease in existing rules, that is West Bengal Minor Minerals Concession Rules 2016 and West Bengal Sand Mining Transportation Storage and Sales Rules 2021. Further, the Government of West Bengal Department of Industry, Commerce and Industries Enterprises has introduced the West Bengal Sand Mining Policy 2021 dated such and such to improve the effectiveness of monitoring and mining and transportation of sand, and to ensure the extraction is carried out in scientific and environmentally sustainable and socially responsible manner. In Schedule 6.3 of the said policy, it was also mentioned that in existing leases, the lease shall not be renewed and shall automatically be resumed and vested with the state government upon expiry of such leases. Then secondly, that they have referred that SG Projects Private Limited, the report of the joint team relying upon which the show cause was issued to the petitioner has duly been scrutinized to verify the claim of the petitioner. On scrutiny of the said report with strict adherence to the written objection, it was established that the petitioner has done illegal activity by the way of constructing wooden bridge, then using suction pump, then mining activity beyond the leasehold area, violating the condition, then using alternate route against and in violation of approved mine plan. Then fourthly, the expiry of the lease, the lessee had willingly applied for release of financial assurance and performance security in the form of bank guarantee on 3rd August 2023, and which has been acted upon by release of the said bank guarantees.
Application for release of bank guarantee.
That is not annexed, but reference is made.
You have a copy of your application for release of bank guarantee. Please give that.
Ah.
Yes.
There is no denial.
Now, my lord, kindly turn to the next page. H. Fifthly,
Yes.
that reliance can be made on the observation of the Honorable High Court such and such. Hemanta Kumar Ghosh, my lord, that fact is slightly different than this fact. And then further I say that on the last date of hearing dated such and such, the additional global, that is the point for maintainability. Then the authority has decided, appellate authority has decided on these counts. So, my lord, I would say, my lord, if a person, a guilty person stands up in the dock and says, yes, I am guilty, what is to be proved? If show cause has been admitted,
No, according to them, similar show cause notice was issued to others, and they have been
factually different.
What factually different?
Yes. Well, there Radharaman's case, the Radharaman could not extract because of the embargo imposed by the district magistrate during rainy season. The path.
Show cause. They have said the show cause was also issued.
Well, I'll show. I'll place that fact. Kindly come to, because district magistrate had accepted that fact. Yes, there was an embargo. So hence, page ta bolo. No, sir. এই মাত্র দেখালাম. Kindly take up their affidavit in reply or second volume page, sir, page. আমি দাগিয়ে রাখলাম, পেজটা বলো না. .263, I'm not placing from 263 because the factual aspect, when auction, then when letter of intent. Kindly come to page 264. The petitioner was unable to carry on mining operation in view of a notification issued by the district magistrate and collector Purbo Bardhaman on 25th March 2021, restraining the movement of all kinds of heavy loaded good vehicles through Golshi to Ghogogram Road via Adrati, which is the only route of the petitioner for communication to the leasehold area. The restriction was withdrawn by a notification issued on 22nd February 2022. So from 25th March 2021 till 22nd February 2022, since the petitioner was unable to carry on mining activities from 25th March 2021 to 22nd February 2022, due to restrictions imposed by the authority, he incurred huge financial loss. So even there are embargoes I have come across by the National Grain Tribunal, where a certain period they could not extract. Those are the exclusions. So this fact is completely different. Now kindly straight away come to page 273, which my learned senior friend Mr. Banerjee has relied, that para 23.
Yes, for some period.
Yes, the entire exercise should be completed within 6 weeks. Only the loss of business for that period when the embargo was on, for that period,
Notification.
yes, that period has to be compensated.
Yes.
So it's completely in a different altogether. And the next aspect, that to Lokesh and the other one, these are the people try to confuse the court. Why I say this? Because this mining companies does not have only one ghat. They, most of the time, they have more than one ghats. So chalan for the other ghat can be one of the reason, and the other reason is one excavation is done, that is the within that 5 years period, then stacking is done, then from there to absolutely. So these are the road challenge from the stock till somewhere wholesaler or retailer,
As per the transportation rules.
as per the transportation rules. So that can be issued even beyond the period of lease period, only for carrying.
Because what he has extracted during the lease period,
Yes.
entitled to carry even after that
Yes.
for definite period.
For the wholesaler, for the retailer, where they would be taking.
Yes.
So, my lord, in my humble submission, my lord, Mr. Mukherjee is here, my lord. In my humble submission, once the guilty person comes to the dock and accepts his guilt, then, my lord, there is no requirement even. Well, it can be summarily decided, yes. That's what has happened. And not only that, he had accepted it and he had asked before the district magistrate, please release my bank guarantees. And on that basis, we have issued the bank officials, please release the bank guarantees. আর কিছু দেখাতে চান স্যার? এটা তো অ্যাপিলেট অথরিটির অর্ডার, আনমেইনটেনেবল। আর কি ফার্দার কি অ্যাপিল করবেন? নো মানে পারহ্যাপস মানে
Leading you.
ইয়েস।
You are leading him. Yes, what do you have to say?
What a kind of factual aspect has been dealt with by the appellate authority as well as the original authority. How this read could go into that question. Article 14 does not apply. Mr. Ghosh's, Justice Ghosh's order in another respect. And so far as soon as he takes back some money, bank guarantee, has he got any right to apply for extension of the new law? If he was not applied for return of the bank guarantee, question would have been otherwise.
Then you would automatically extend.
No.
যেখানে অ্যাকসেপ্ট করে নিয়েছে, অ্যাডমিট করে নিয়েছে,
admitted all the fact. He has committed this. There is a violation of the route. There is a excavation beyond the area. Or guilty charged with this, all the charges she has accepted. No, this committed. Kindly condone my lapses. As soon as Bangalore has accepted the money, he has no right.
I have nothing more to add. I will add up the submission of Mr. Hall.
Yes, my lordship has kindly come to my lord, page 20 of the affidavit in opposition and page 228 of my writ petition.
228.
Yes, 228 of the writ petition and page 20 of the writ petition.
Yes. It's the same document.
Same document.
Yes.
See the names. Same allegation. Same allegations. Same date, 14 December 2020. Same language. But I am reading from page 20 of the opposition, and lordship kindly matches this with page 228 of the writ petition. Whereas on the basis of inquiry reports received, it appears that illegal sand mining activities are being carried out by you in respect of your leased out area block at Silighat area under Patrashire PS beyond the provision of lease. And whereas such illegal activities of the lease are in contravention with the existing rules, guidelines, norms, and procedures of the sand mining, and whereas such illegal activities of the lessee are also causing environmental damage in that area. Therefore, you are directed to reply within show cause within 3 days of receipt of this letter why appropriate penal action will not be taken against you in the aforementioned district. Radharamon and SG project, same date, same notice, same show cause. And lordship kindly sees page 229, which my landed senior had already placed before lordship's court. Demand of submission, demand of submission of penalty for illegal sand mining to Radharamon. So he pays 1 lakh and his show cause is withdrawn and he carries on.
Show me the order of withdrawal of show cause of Radharamon.
But after this he carried on. He lordship kindly
Show me the order of withdrawal of show cause of Radharamon.
No, but it's, no, sorry to interrupt.
Yes.
But a challan is issued. For what purpose? The business is doing. That is implied because they will not sub us. I am not Radharamon. This is implied. Let them deny he is not doing the
But may I
business.
say one thing? Let them file a separate affidavit dealing with paragraph 36 of my declaration. They have avoided in their opposite. They have avoided.
Doctrine of non-traverse would apply.
Yes, and yes.
Why are you inviting them to file? Anything more, Mr. Banerjee?
My lord.
Anything more to give?
No, our-
Sir?
My lord, he is also appearing. Next matter, he is also appearing. My lord, the last occasion, extra imperative to remind your lordships.
Which item?
স্যার এখন আইটেমটা ডাক এখন অন্য আমাদের
94.
94, yes.
Extremely important to remind you also the last occasion, my lord asked my friend, senior friend, that will senior advocate, my lord. So my lord, take instruction.
Yes, yes. What is this matter?
Yes, this is that matter, my lord, where the filling up of water body 4C was issued.
Yes.
5 acres of land.
Have you got that?
Yes, I got the instruction. No, my lord.
Sorry, it's the
Saw,
authority.
yes, my lord saw the authority, that is the with the DLLRO, but BLLRO had issued the 4C5. So instead of, my lord was of the opinion, instead of relegating before the learned tribunal, let's do it here so that my lord would be giving us liberty to act on the basis of 4C5. So that's instruction, my lord, I have got. That yes, my lord can do it, my lord, and with the liberty, will the appropriate authority will issue.
BLRO do not have any authority.
Yes, BLLR.
Pass it and pass the directions. But answer. At least একটা মনে ঘাট থেকে নামলো আপনাদেরও
নাম দিতে বলছে
কেন তোমার নাম থাকবে না?
না না আমার নাম
2, straight away to page.
225,
Hmm.
224 onward.
Notice is dated 20th of July 2020.
Yes,
That's
yes.
correct.
Page
Page 224 onwards.
224. 78,
Yes.
228 also.
Yes.
The same.
So all these were issued by the Block Land and Land.
Yes.
Land Reforms
There's
Office.
no dispute.
So the statute says collector. So
Collector.
DLRO is the collector. Please
Yes.
give me that notification.
No, on the other occasion when.
Don't you have a
No.
here? But
One thing, my lord. Since my lord found is without jurisdiction, that's why my lord squashing. But that will not prevent to proceed in accordance with law.
taking steps.
Do not point out who how then.
The petitioner
Well, one thing, one contempt is pending. My lord is entering into the contempt because this is the before Justice Kapoor. Kindly clarify that. That says the contempt is pending, not before as a not.
It is however, no, at
My lord, in this matter, I am appearing for the private respondent, my lord.
Vijay, my lord.
All the private respondent.
দেড়টা অব্দি বসে থাকছেন ভুলে যাচ্ছেন 5টা 5:30 সময় ডেকে দিচ্ছি
Your Lordship, learned advocate for the petitioner is appearing before is on legs and he's appearing before
you
the.
are here, you are for the petitioner. Yes, what is this matter? Please start.
My lord, this matter is, my lord, related to the, my lord, enemy property, my lord, and the petitioner are the licensee, my lord. I am appearing for the private respondent. On the last occasion, Lordship directed the Union of India to file a report, my lord.
Yes.
If your Lordship kindly recalls.
Where is the Union of India? Yes, who is for the Union of India?
My lord, on the last occasion, Mr. Trivedi was appearing, my lord, Mr. Dheeraj Trivedi, for the Union of India.
Learned advocate.
Deeply obliged, my lord.
Yes.
But on the last occasion, my lord, Lordship directed the state to take
instructions. Mr. Dor, what is your instruction?
My lord, in this matter, my lord, I am appearing on the respondent number 6, Hitco, my lord. I have to make one submission, my lord. My lord, this is a report and.
Yes, Mr. Dor, where is your report?
Page 76.
My lord, also this problem.
কি বলছো
In this writ petition, my lord, one document has been annexed by the writ petitioner.
oh my oh that famous oh my god yeah
One RTI apply,
kindly
my lord.
come to page 76
Page 76 of?
yes I can recollect
76
that
of
we
what? Writ petition?
yes page 76 of this writ petition.
Yes.
If this factual narration is true, then I have a case. If this is false, I don't have a
One more thing remains.
Have you filed the report?
Well, can you see the report?
Yes, what is there?
Section 4 is there, section 6 is there, then award is there, everything is there. Date দেখে কি করে form 13 সব
Which paragraph, Mr.
মানে award of eligible persons was published on 13th February 2003 and then para 3. Manoj, kindly come to para 3.
Yes.
Section para 1 is section 4, then para 2 is section 6, then para 3 is award, then para 4. 55 number of awardees were declared as eligible persons, which included both verified and non-verified awardees. The applicable award amount had been civil deposited in case of non-verified awardees.
Who are the petitioners? What is their case?
My case is that if the award money was deposited in 2016, which is beyond the prescribed time, whether that fact is correct or not, because my page 76 says out of the persons whose ownership could not be verified, their award was deposited with the learned court on 4th November 2016. That date needed to be clarified. Because if it is 2016,
when it was deposited, Mr.
Even I take it 2016.
Then the entire process.
Even I take it 2016. the 5-judge bench of that judgment will come into play. Even civil deposit, revenue deposit is also
Yes,
a
yes.
proper deposit.
I'm not on that. I'm on
না, copy না। ধ্যাৎ, কিছু নেই, মামলা ফালতু।
My lord,
But
my
I like
submission,
that-
my lord, but I'm appearing on behalf of the HITCO, my lord. Respondent number 6.
Yes.
One document has been annexed in writ petition, my lord, page number 64. One RTI reply, my lord.
Yes.
My report says, my lord, this document has been forced, my lord. And
Yes,
in that respect, my lord, I have submitted the report and document and certificate also by signing person signing this document, my lord, and the original letter which has been issued, the same letter number and the register, my lord.
Yes, sir. This is a serious allegation.
Serious. This is serious.
They should be put in for a cost.
This is serious. This is serious. I can't defend that.
It's forged.
Yes, that was our hunch.
Please take instructions.
If he says that, my lord, I cannot.
Please take instructions.
I have annexed the original document also, my lord, which has been
That 76 is not 76. The date is perhaps the correct.
Maybe 76. How have you got this 64?
That I'll have to take instruction.
Please take instructions. The reports filed by the
Get a copy to it.
Yes, so it's that matter of Milord the Gangasagar Mela, wherein Milord
Mukherjee was there. Yes, where is Mr. Mukherjee? Yes, what happened?
this year also, Milord, even apart from whatever, Milord, the utilization that was done in the previous year, this year for car parking also, this has, Milord, gone into my, Milord, my
Where
court
is Mr.
state.
Tapan Mukherjee?
Mr. Mukherjee, Milord, I insisted, personally, I talked to Mr. Mukherjee. Mr. Mukherjee said, still DM has not forwarded the report. That is my personal, Milord, information. Milord, I should not.
Where is Mr. Mukherjee? Ask your junior to call him.
Yes.
Where is Mr. Jagabandhu Rai? Where is Mr. Pranab Haldar? Pass over. Ask him to come. Yes, call the next matter. Yes.
Lord, I appear for the state.
Yes.
মামলা চলছে কোথাও নাকি?
The petitioner's land was requisition under the Defense of India Rules 1939. Subsequently, it was continued under the Act 2.
Yes.
And in spite of several representations, no compensation was paid.
So you are challenging the order dated 11th of September 2024.
My lord.
Where is that?
133.
Yes, what is wrong in this order?
We by virtue of operation of the law, as well as by different judgments passed by this honorable in Sobita Mundo's case and Mandodari Bhakat's case, on last occasion I produced before your lordship, we are entitled to get back the possession of the land. We made a representation for handing over possession that has not been dealt with in this application. And this is the fourth round of litigation, my lord.
Yes, my lord, this is the second time the matter is being taken up. My lord, after the first time, my lord, I personally went through the papers. Now, my lord, I discovered something, my lord, which went unnoticed previously. My lord, under the act, it was requisitioned. Thereafter, my lord, under 1951 Act, which is, my lord, West Bengal Requisition Land Continuance of Powers Act, this has stood vested, this whole land. Because, my lord, under section 5 of the concerned act, the vesting takes place on publication of notification. That is done. Thereafter comes the question of compensation in 6, but the vesting is not, my lord, contingent on payment of, my lord. Yes. Yes. My lord. এইটা লেখা আছে সরি একটু প্লিজ
Yes.
My lord, may kindly take up 5, which is the relevant, my lord. ওনাদের আছে না, এটা তো আমাদের ওটা
My lord, subject to the provisions 1951 Act. Subject to the provisions of subsection 3, the state government may at any time when any requisition land continues to be subject to requisition under section 3, and I will show that it was, my lord, subject matter of the act was ongoing, acquire such land by publishing in the official gazette a notice to the effect that such government has decided to acquire such land in pursuance of this section. When a notice as aforesaid is published in the official gazette, the requisition land shall, on and from the beginning of the day on which the notice is so published, vest absolutely in the state government free from all encumbrances, and the period of requisition of such land shall end. No requisition land shall be acquired under this section except in the following circumstances, namely, where any works have during the period of requisition been constituted on, in or over the land wholly or partially at the expense of the state government, and the state government decides that the value of or the right to use such work should be preserved or secured for the purpose of the state government, or where the cost of restoring the land to its condition at the time of requisition would, in the determination of the state government, be excessive, having regard to the value of the land at the time. Any decision or determination of the state government under subsection 3 shall be final and shall not be called in question any court. For the purposes of clauses, subsection 3 works includes buildings, structures, and improvements of every description. Now, my lord, the concerned notification I have found, my lord, section 6, my lord, deals with the payment of compensation, but my lord, that does not affect, my lord, unlike the, my lord, Land Acquisition Act, my lord, there is no effect of lapse or anything. Or the, my lord, acquisition, my lord, as far as I have understood, is not contingent upon performance of 6. On 5 being made, the, of course, the person concerned shall have a right to receive compensation under 6. That is a different issue altogether. কোথায় আছে? কোথায়? 5 বসেইনি, 5-এ আছে? করলে তো হবে না ভাই। আমাকে কাগজগুলো তো তুমি দিতে পারবে না, তুমি তো এটা জানার কথা না। ওকে বলো আসতে। এ কি? আমি আপনাকে একটা কপি দিয়ে দেবো। দেখ, একটা ইয়ে রয়েছে 1982 এর গেজেট নোটিফিকেশন বার কর। কেউ পাইনি, আমি করতে পারি। My lord, if I may say two things at the same go, my lord. My lord will kindly take up, my lord, section 1 of the said act, of the act your lordship is looking at. Section 1, subsection 3, my lord, I will directly read. It shall come into force on the first day of April 1951 and shall cease to have any effect of the expedition of a period of 3 years from that date, except as respects things done or omitted to be done before this. So, my lord, so 3 years was the, my lord, initial, my lord, life of the act. But I say, my lord, the notifications were made on 17th March 1983, they were published. 17th March 1983, they were published. However, my lord, in the interregnum, there has been, my lord, a notification of 1982. There has been several, my lord, knows this, my lord, there have been several notifications extending the life of this act. By the last one, it was extended up to 31st of March 1983. And, my lord, days before that, on 17th March 1983, this notification was made, my lord. And, my lord, if I may open this to the concerned page, your lordship will see in the schedule, my lord, they contain that their land is in Dag number 2095 in its entirety. Dag number 2095, my lord, has been. Yes. The schedule Mouja Kalna so and so, my lord, revisional settlement plots in full. Second plot is 2095. Yes. And all these plots, my lord, including, my lord, part of 2100 is the plot on which, my lord, the government is there, my lord. So it was given in one go. The notice, if I may also point out, my lord, the order is of 10th November 1980. My lord, will find in the preceding page just after the word notice. Yes. Though the order is of 10th November 1980, it was actually, my lord, published under section 5 on 17th March 1983, which date will appear from the first, my lord, page of the bunch of documents which I have handed over to your lordships. The order had a copy though. 83 টাই দাও। দে একটু বার করে দাও।
So, consider this.
My lord, this Act 2 was time to time, it was validity of the requisition was extended.
Typed copy.
Lastly, into a 1996 Amendment Act.
Sir, Act 2 and this, there are some different provisions. Have you considered this?
Extension of 51, so far the 51 Act is
I'm
concerned.
aware of the decisions which you are citing. I'm aware of those provisions, but there is certain distinctions as far as 1948 Act and this Act.
Now this 51 Act, I could not find out in spite of my several efforts.
Giving, please
I will
consider
give
this.
here and now. Just my junior has just arrived, my lord, he will give all the papers.
Yes.
My lord, I will also
I will
hand
take
over,
it
my
up
lord.
in the next
To be filed.
যে বুধবার করিস নি। তো ছেড়ে দে। আচ্ছা, খুলে বার কর।
Considering the issues involved in this writ petition, this court feels that yes, 99 who is appearing?
I am for the identical.
Same matter.
Identical
99
matters, my lord.
9900.
Yes, 3 matters identical.
Same order.
Yes.
Affidavit.
Yes.
Affidavits. দিচ্ছি একটু ওনাকে দেখে দাও না
আপনি নেবেন
Yes.
একটু নেবেন
Mr. Mukherjee.
আমি পেয়ে তো
Yes, well appearing. Yes, what happened to that matter? Please call the passover matter. Hey.
By virtue of the last order, my lord recorded everything that every year my land is being utilized for the purpose of, my lord, organizing the Ganga Sagar Mela. So this cannot be go on perpetuity. That's why your lordship directed. And I, my lord, by myself, my lord, considered that don't pass any interim order. I am not pressing it. This year also.
What is your instruction?
Mr. Mukherjee, if your lordship can fix tomorrow, my lord, because I could not take.
Where is the report?
Report, that's why Mr. With Mr. Mukherjee, my lord, that is it. Report is with Mr. Mukherjee. Right.
When you will file this report?
If your lordship please that to fixed any day.
Not fix it Monday, my lord, as to be mentioned. Since my learned senior friend is suggesting the report is lying with Mr. Mukherjee, let a copy be handed over in advance.
Yes.
I will make myself prepared and come back on Monday.
Monday. Monday, next week, Monday or
The learned advocate appearing for this.